ನೋಡಲ್ವಾ ದಿನ? Similarly, the memo filed by the Learned Counsel for the petitioner is also noted, and the same would be taken up for consideration at the time of final disposal of the writ petition.
Madam.
Please amend the writ petition.
Yes, madam.
Yes, next. Chaitanya Kumar,
My lord, this suit has been dismissed for non-prosecution in the trial court, my lord. I will seek instruction any next date.
Learned Counsel for the petitioner submits that the suit before the suit from which the present writ petition arises was dismissed for default. He therefore submits that the writ petition does not survive for consideration for the present.
Yes.
So in that view of the matter, this petition is disposed of. It is disposed of as it does not survive for the present. However, liberty is reserved to the petitioner to file appropriate petition in the event the suit before the trial court is restored.
Please.
Let's say which time final limits and comply the office objection.
Non-compliance of.
Office of
ನೋಡಿ pass over.
No, not.
ಮಾಡ್ತೀರಾ?
1 work.
1 week time is granted to do the needful.
Lord, I seek dispensation of notice to the respond number 4 to 13 and
A
17.
memo is filed by the Learned Counsel for the petitioner seeking dispensation of notice to respond number
4 to 13
4
and
to
17.
13. And
17.
In view of the memo, notice to respondent number 4 to 13 and 17 is dispensed. 13 not claimed ಅಂತ ಆಗಿದೆಯಲ್ಲ.
Not claimed ಅಂತಾಗಿದೆ, my lord, since it will not be a.
12 ಅಂತ ಮಾಡಿ, 6 to 12 ಅಂತ ಮಾಡಿ.
Please, my lords, I may permit it
The
to.
notice issued to respondent number 13 is not claimed. The address of the respondent number 13 mentioned in the trial court corresponds with the address mentioned in the cause title of this writ petition. Hence, notice to respondent number 13 is held sufficient. Officer is directed to show his name in the cause list and also indicate that notice to him is held sufficient.
Matter pertains to, my lords,
Ready na?
yes, my lords.
Both of you are ready. Suit is filed in which year?
Suit is filed in the year, my lords.
12.
12, my lords.
2012.
12.
Kudi.
Three applications have been challenged before this honorable court, my lords. One is
What is the suit for?
suit for partition in separate position, my lords.
Hmm.
The petitioner is defendant number 14 before the trial court, my lords.
Defend number
14.
Ah.
An application, my lords, subsequently, my lords, earlier power of attorney of the defendant number 14 was examined, my lords. His evidence was discarded. Thereafter, the defendant number 14 himself stepped into the witness box, my lords, and the evidence was closed. Subsequently, my lords, after 2 months, my lords, an application for reopening side of the defendant was filed for further evidence, my lords, to lead further evidence in respect of the partition, my lords, which was earlier effected in the year 2001, my lords. And another application for recalling of PW1 for further cross-examination, my lords.
Hmm.
That application was rejected only on the ground of delay in laches, my lords, and sufficient opportunity was granted to the
This is IA number?
I number 22, my lords,
21 and 22.
21 and 20.
21 is for what?
I number 22 is with regard to the recalling of PW1 for further cross-examination, my lords.
A 21?
I number 23, my lord, is for reopening side of defendant, my lords, to lead further evidence. my lords.
You are not examined yourself.
I have examined myself, my lords, further evidence with regard to the witnesses who have been parties to the earlier partition, my lords, which was effected in the year 2001, worthy of the partition, my lords.
ಎಷ್ಟು ಕಾಸ್ಟ್ ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
I leave it to the honorable court, my lords.
ಬೇಕಾದ್ರೆ
Yeah, I'll leave to the.
ಬರ್ಕೊಳ್ಳಿ. The
The only thing
defendant
is, let it be early conclusion. They are dragging on the matter.
in OS number 147 of 2012 on the file of the principal senior civil judge Vijaypura is before this court, challenging the correctness of an order dated so and so by which his applications IA number 21 and 22
My lords.
to recall
My lords, I number
Freedom.
22, my lords.
22,
I number 22, 23 and 24, my lords.
22, 23 and 24 to recall the stage of the suit and to recall PW1 for further cross-examination and to recall the stage of the defendant's evidence were all rejected. Next para. The suit in OS number 147 of 2012 was filed for partition and separate possession of the plaintiff's share in the suit's real properties. Full stop. The defendant number 14 is a purchaser.
Yes,
Are you a purchaser?
no, my lords, I am the related to the family, my lords, but there was a partition worthy between defendant number 14 and other defendants, my lords, wherein I am leading the evidence on the basis of,
You are a member of the family.
yes, my lords.
The defendant being the maternal grandson contested the suit and claimed that there was an earlier partition,
Yes, my lords, worthy,
there was an earlier partition between the parties, which was reported to the revenue authorities.
yes, my lords, on executed on 10/1/2001, my lords.
Earlier partition on 10/1.
10/1/2001,
2001, which was,
which was reduced in writing, my lords.
which was reduced into writing,
Please,
based upon which a worthy was submitted to
Yes.
the revenue authorities.
yes, my lords.
Full stop. Based on these contentions, the suit was taken up for trial. Full stop. After the conclusion of the evidence of the plaintiffs, the suit was set down for the evidence of the defendants. Full stop. The defendant number 14 was examined as DW1
Yes. Not DW1, my lords.
on
My lords, he was examined on 30/11/2019, my lords.
13/11/2019, and the case was set down for arguments.
Yes, my lords.
Full stop. At that stage, the defendant number 14 filed an application to recall the stage of the suit
Please, my lords.
and to recall PW1 for further
Further
cross-examination, and also to recall the defendant's evidence, and also for permission to lead further evidence of the defendants. Full stop. The said applications were contested by the plaintiffs on the ground that the same was designed to protract the proceedings. So the trial court, in terms of the impugned order, rejected all the applications on the ground that
Page number 168, my lords.
on the ground that
No reasons has been assigned and the delay in latches, my lords. Page number 168.
no reasons was mentioned in the applications for recalling PW1 for further cross-examination, and that the applications were filed belated. Being agreed with the said order, the defendant number 14 is before this court. The learned counsel for the defendant number 14 contends that the sued properties, one property, na?
No, my lords, there are several properties, my lords.
Which is the property which has fallen to your share?
That has not been specified.
The learned counsel for the defendant number 14 submits that there was a prior partition between the family members which was reduced into writing, based upon which certain revenue entries are brought about. He submits that these facts could not be confronted to PW1, and therefore PW1 had to be recalled for further cross-examination. He also contends that the defendant number 14 has now been able to secure certain witnesses to witnesses who would speak about the partition, the family, and therefore an opportunity deserves to be granted to the defendant to recall PW1 for further cross-examination and to lead further evidence. Full stop. This is, however, contested by the learned counsel for the plaintiffs, who contend that the defendant number 4 ought to have availed the opportunity to cross-examine PW1 at the earliest point in time. He also invited the attention of the court to the applications filed by the defendant number 14 and contended that no reason is mentioned as to why PW1 has to be recalled for further cross-examination. He also submits that no reason is mentioned in the application as to why defendant number 14 has to be granted an opportunity to lead further evidence. Full stop. Next, I have considered the submissions of the learned counsel for the petitioner, defendant number 14, as well as the learned counsel for the plaintiffs. Next para. The perusal of the application filed by the defendant number 14 to recall PW1 for further cross-examination shows that
Regarding,
the defendant number 14 had alleged that his advocate, that the advocate who was engaged by him earlier had not cross-examined PW1 as per the written statement, as per the averments made in the written statement, and the genealogy
is this,
mentioned in the written statement. He also alleged that his advocate had not exhaustively cross-examined PW1. Full stop. He claimed that the advocate now on record had advised him to file an application to recall PW1 for further cross-examination. Similarly, in the application filed to lead further evidence, the defendant number 14 did not mention any reason as to why he could not lead further evidence. Full stop. Nonetheless, since the defendant number 14 has raised a substantive defense that there was a prior partition between the plaintiffs and the defendants, and that the same was given effect to, an opportunity deserves to be granted to the defendant number 14 to establish his case. But however, subject to certain conditions, so as to ensure that the defendant number 14 does not protract the proceedings any further. In addition, the plaintiffs deserve to be compensated for the time lost in litigation. Full stop. Consequently, the following order is passed. The writ petition is allowed. The impugned order passed by the trial court rejecting IA number 21, 22, 23 and 24
please.
are set aside, and the applications filed by the defendant number 4 are allowed, subject to the condition that the defendant number 14 pays cost of rupees
I leave to the court, my lord. Please.
10,000 payable to the plaintiffs on the next date of hearing. In addition, the defendant number 14 shall without fail cross-examine PW1 on the next date of hearing. Stop. He shall also take steps to examine any other witness on his behalf, either on the next date or on the following date that may be fixed by the trial court.
Yes.
Full stop. If the defendant number 14 fails to avail this opportunity, the trial court is at liberty to dispose of the suit on merits and in accordance with law. Since the suit is filed in the year 2012, the trial court is requested to dispose of the suit as early as possible, at any rate within a period of 6 months from the date of receipt of a copy of this order.
Oblige me.
Ratna Shivayogi Mutt. 1 week time is granted to do the need. R4 yaar refused, huh? The notice issued to the respondent number 4 is refused. Hence, notice to the said respondent is held sufficient. Office is directed to show the name of respondent number 4 as served in the cause list. What about steps to R3? R3 tirogidharallama. 2 weeks time is granted to take steps in respect of deceased R3, failing which the petition against R3 shall stand abated. Yes.
Your 11 and 12 both have become infructuous, my lord, due to disposal of main matter.
R1 yaar,
Lordship, is
R1 insufficient address.
principal, my lord, because the petitions itself become infructuous, my lord.
You can dispose it off. For learn counsel for the petitioner submits that the petition has become infructuous. The
Well, also
petition is
same.
noted and the petition is dismissed as having become infructuous. Yes, next.
Same, my lord.
12 also, same order. 13,
Serial number 13, my lords, I appear for the petition. There is an office objection, my lord. Actually, what this petition has been filed for seeking parole, my lord.
What is that?
Um,
14, objection number 14.
Yes, my lord. My lord, yes, I have given the council submission, my lord. Right now, I have been placed at my Ballari jail, my lord, and the endorsement is being given by the chief superintendent of my jail. Hence, hence arraying party, the superintendent of police of Raichur is not necessary.
Where's the impugned order?
Impugned order is at annexure F, my lord, at page number 13, I guess.
Police Adhikshakaru.
Yes, my lord. On the right top corner, as my lords may see, ಇವರಿಗೆ ಮುಖ್ಯ ಅಧೀಕ್ಷಕರು ಕೇಂದ್ರ ಕಾರಾಗೃಹ ಬಳ್ಳಾರಿ. So I have been placed in this jail. So even I have submitted my representation to my CS,
No, that
chief
is right,
superintendent
but then
of
you
jail.
have to make the police superintendent as a party alwa.
Yes, my lord, but the intermediary is my chief superintendent, my lord. I have been placed in the jail. And the chief superintendent what inquires my release on parole to the superintendent of police, my lord. Hence, I am not answerable to the what
No, then you should only
superintendent of
ask for,
police.
why do you challenge annexure F? Annexure F is only a report of the SP.
Yes, my lord.
So therefore, why are you challenging annexure F?
Yes, annexure F is the only order which is coming in my way,
Correct, appa.
declining my parole, my lord.
So therefore, you only seek for parole. Why do you challenge annexure F?
Yes, my lord. As per annexure, my lords may have a look. Annexure D, my lord. Annexure D is my representation. I have given my representation to my chief superintendent, and then he sends a local report inspection, and then annexure F is given by the chief superintendent that I am not eligible for parole. Hence, I am challenging that order, my lord.
Now, whether the jail superintendent has passed any order rejecting your application for parole?
No, my lord. Actually, ಏನು ಅಂತಂದ್ರೆ ಇವ್ರು ಯಾವ್ದು ಆರ್ಡರ್ ಪಾಸ್ ಇವ್ರು ಏನ್ ಮಾಡ್ತಾರೆ ಅಂತಂದ್ರೆ ಅವ್ರು ಕೊಟ್ಟಿರೋ ಆರ್ಡರ್ನೇ ನನಗೆ ಕಾಪಿ ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ ಅಷ್ಟೇ.
Aitappa, but some order should be passed by the concerned jail
ಅವ್ರು
authority.
ನೋ ಮೈ ಲಾರ್ಡ್ ಅವ್ರು ಏನ್ ಆರ್ಡರ್ ಕೊಡ್ತಾರೆ ಅದನ್ನ ಎಂಡೋರ್ಸ್ಮೆಂಟ್ ಮಾಡಿ ನಮಗೆ ಕೊಡ್ತಾರೆ ಸ್ವಾಮಿ ಅಷ್ಟೇ ಇರೋದಿದ್ರೆ.
But this is not addressed to you by the jail authority.
Yes, my lord. Copy is given to me. Copy is given to me, my lord. ಈ ರೀಸನ್ ಅವ್ರು ನಾನು ಕೊಟ್ಟಿದ್ದಕ್ಕೆ ನಾನು ನಿನಗೆ ಬಿಡ್ತಾ ಇಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ ಸ್ವಾಮಿ.
Yes, madam. Find out.
Please, Your Worship.
Find out as to why the jail authority has not issued appropriate endorsement about the application for parole.
Please.
Full. Office objection at serial number 14 is kept open. In the meanwhile, the learned SCGP is directed to secure information from the jail superintendent as to why jail superintendent
Not pass the appropriate order.
information from the respondent number 4 as to why no endorsement is issued to the petitioner regarding consideration of his application for parole.
Please.
List on yavattu
15th, Your Worship. Wednesday,
15th January.
15th. January.
Obliged.
1 week time is granted to do the needful. R6 to R8, please. 1 week.
Waiting for the petitioner, my lordship.
1 week.
My lordship, in this, I'm seeking for interim order, my lordship.
No interim order. First
My
you
lordship.
serve the respondents.
During
Without
course of the day, I
service, we
will.
can't. Ondsati notice issue ಆದ್ಮೇಲೆ serve ಆಗ್ಬೇಕಲ್ವಾ?
My lord, I undertake to file wakalat on behalf of R5, my lord.
Mr.
Chaitanya Kumar CM.
Mr. Chaitanya Kumar Chandraki. Chandraki undertakes to file power for respondent number 5.
Lordship.
Office is directed to show his name in the cause list. Yes. List on, when do you want it?
Next week, I need it. 15, my lordship.
Yes, next.
Copy code.
Santosh Hanumantrao.
Kindly next week, Manas.
Yeah, office objection is 19. Actual D. Office objection regarding furnishing of certified copy of attested deed is overruled. What about process R7 and R9?
Already so.
Huh?
They have appeared, my lords, they have filed wakalat.
R7 and R9.
No, R8 and R9, man. R7. Await.
R7
Seven,
returning officer and R9 chief manager. 1 week time is granted to pay, process and
Please.
deposit other requisites.
Please.
To issue notice to respond number 7 and 9.
Yes.
Failing which the petition against the said respondent shall stand dismissed. Manjunath Ginni.
I have paid the process yesterday, my lord.
ಇವಾಗ process pay ಮಾಡ್ತಾ ಇದ್ದಾರೆ. I have already taken notice for R R6 to R10 and
What about R5?
sorry, R5 to R8 and R10 to R14.
Mr. Shivanand Patil
I already filed my wakalat, my lord.
has entered
Today I
appearance
also
for
filed an
respondent number
application
5
for-
to 8 and R10 to R14. Hence, office is directed to show his name in the cause list.
Today I am filing also an application to for declaration of the result of.
The matter, my lord, pertains
No
to no
confidence motion,
confidence
I
motion, my lord. There is no clear
The
15
rider is
days,
at
my lord.
order.
There is no clear 15 days.
Yes, what is this 15 days notice ilva?
ಇಲ್ಲ. The notice is issued on 20th 12, my lord.
Notice
According
Date
to
was
them-
fixed on
According to
4/12.
them, it's according to me, it is 15 days, according
ಹೇಳಿ,
to
ಇದೇನಂತ ಹೇಳ್ಬಿಡಿ ಕೊಡಿ.
Notice dated on 20th 12.
When was the notice issued?
20th 12, my lord.
20th of
12,
12
2024.
20th December 2024. What is the
24.
date?
4th January 2025.
January.
ಎಲ್ಲಾಗುತ್ತೆ?
There is 15 days.
15th day ಆಗುತ್ತೆ correct.
15 clear
Clear
days
days,
ಅಲ್ವಾ?
bhai.
The
There is
15th
no
clear
clear
days that of course there is an interpretation, but now there is a Supreme Court also judgment that is a fractional violation. That may not, if it has not prejudiced them in any other manner, that cannot be also considered because that
Who
is not
knows?
mandatory, that is only directory.
Correct.
Mandate.
ಇನ್ನೊಂದ್ ದಿನ ಇದ್ದಿದ್ರೆ ಇನ್ನು ಸ್ವಲ್ಪ ದುಡ್ಡು ಗಿಟ್ ಕೊಟ್ಟು ಎಳ್ಕೊಳ್ತಿದ್ರೇನೋ.
But
If there's one more day, maybe this petitioner would have,
deliberately ಮಾಡ್ಲಕತ್ತಿದ್ದಾರೆ ಅಲ್ಲಿ, deliberately ಮಾಡ್ತಾ
ಹ್ಮ್.
ಇದ್ದಾರೆ. Nobody can do anything about that.
if there's one more day, the petitioner could have convinced the other members to vote in his favor.
That's again hypothetical interpretation. For 10
Hypothetical ಏನ್ ಬಂತು?
ಅದ್ರೊಳಗೂ ಜಜ್ಮೆಂಟ್ ಏನು ಅನೌನ್ಸ್ ಇದು ಮಾಡಿದ್ದಾರೆ that for 10 long days he does not do anything.
Sir, the race is not won till the line is crossed.
I am not going to dispute because just there one judgment no ಇದೆ that 15 clear days according to law of lexicon and ಏನಿದೆ that is there.
ಹ್ಮ್.
But the Supreme Court has also come down on that stating that that is not actually mandatory, it
No,
is
no.
only directory ಅಂತ. ಅದಕ್ಕೆ ಅದು argument ಮಾಡ್ತೀನಿ ಈ orders ನೀವು pass because what
No,
happened.
I will not pass an
Huh?
order unless you, it will be like disposing of the writ petition itself.
dispose ಆಗ್ಲಿಕ್ಕಂತ.
ಹೇಳಿ, ಇವಾಗ್ಲೇ ಹೇಳಿ, ಹೇಳಂಗಿದ್ರೆ ಹೇಳ್ರಿ. Ready?
Yes, madam.
Yes, yes.
You ready?
Yes, sir.
ಹೇಳ್ರಿ. ಎಷ್ಟೇ ನಿಮ್ ಕೇಸು?
ಅಷ್ಟೇ pa.
ಅಷ್ಟೇ, ಎಸ್.
ಅಷ್ಟೇ 15 days ಅವ್ರು clear notice ಅಂತಾರೆ.
And
May I
one
just pass
judgment
on?
is there, my lord, the writ petition,
It's not necessary, yes.
please.
May I just pass on judgment, my lord?
ಕೊಡಿ. Yes. No, you said there's some Supreme Court judgment. Where is that?
ಅದರಲ್ಲಿ ರೆಫರೆನ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್. ಪ್ಯಾರಾ ನಂಬರ್ 12 ನಲ್ಲಿ.
ಹ್ಮ್.
Now come down to the next page, my lord. Nineteen ಅಂತಿದೆ. The existence of this provision in section 36 is a further reasoning for thinking that the provisions as regards to any motion or proposition of which notice must be given in section 27(3) is only directory and not mandatory. We are therefore of the opinion that the fact that some of the councillors received less than 3 clear days notice of the meeting did not by itself make the proceedings of the meeting or the resolution passed thereby invalid.
Full bench of this court,
But this is Supreme Court. ಅದಕ್ಕೆ
correct, a full bench
full
of
bench
this
of the-
court has held
Channamoswamy ಅಂತ ಏನಿದೆ?
The purpose of 15 days notice is number one,
Yes,
for the assistant commissioner to arrange a meeting. Number two, it is to arrange or give some time for the petitioner to convince the members not to go for the no confidence or to vote in his favor or her favor. So this 15 days period has to be read as mandatory. That is a judgment declared
See,
full bench of
Puttaswamy
this
case.
court.
ಈ ಪುಟ್ಟಸ್ವಾಮಿ ಕೇಸ್ನಲ್ಲಿ
So therefore, I am a party to that judgment. So I
Dis-
can't,
ಡಿಸ್ಪೋಸ್ ಮಾಡಿ.
ಅದೇನ್ judgment ಸಿಗುತ್ತೆ
The
ನೋಡ್ರಿ.
direction that this, because this is third round ಆಗ್ತದೆ.
But then we can,
The third round ಆಗ್ತದೆ, the assistant commissioner is deliberately doing that. First time ಇದು ಒಂದು fault ಇಟ್ಟು ಕಳ್ಸ್ಕೊಟ್ರು. Second time ಇದು.
in fact, in one case, I have directed the deputy commissioner to take action against the assistant
ಇದು
commissioner
ಸೇಮ್ ಕೇಸ್ ಆಗಿದೆ.
who deliberately.
This is the
issues
second round again. Completed now, the third round I will have to go again for.
full bench judgment ಹೊಂದಿದೆ ನೋಡಿ.
ಸಿ ಪುಟ್ಟಸ್ವಾಮಿ ಕೇಸ್.
ನೋಡಿ ಅಲ್ಲಿ ಕೊಡ್ತಾರೆ ನೋಡಿ. ಬರ್ಕೊಳ್ರಿ. The petitioner who is a president of a gram panchayat, president of ಇಷ್ಟೇ ಯಾವುದು?
ಸುಂಗಠಾಣ್ ಗ್ರಾಮ ಪಂಚಾಯತ್.
ಸುಮ್ತಾ.
ಸುಂಗಥನ್,
ಸುಂಗಠಾಣ್.
ಹ?
ಸುಂಗಠ.
ಸುಂಗ್ಥಾ.
SUNGHTAN.
ಮತ್ತೇನೋ ಬರ್ತಿದ್ರ ನೀವು ಸುಂಗತಾನ್ ಅಂತ.
ಸುಂಗಠಾಣನೆ.
SUNGHTAN.
Yes, sir.
Has filed this petition challenging the notice of no confidence issued by the respondent number 3. Next para. The petitioner contends that he was elected as the member of the Gram Panchayat during the year 2020 and was later elected as the president of the panchayat. Full stop. When things stood thus, comma, the members of the panchayat had moved a notice of no confidence, which was challenged before this court in WP number 203392 of 2024. Full stop. The said writ petition was allowed by this court in terms of the order dated 29/11/2024 on the ground that
On the ground that the motion that was moved on the recommendation, countersigned by the PDO. PDO has no
On the
business to
ground.
countersign.
the motion was moved on the ground that
Countersigned by-
the no confidence motion moved by the members was countersigned by the
PDO.
PDO or Panchayat Development Officer. Full stop. Later, 9 members of the Panchayat out of the total strength of 12,
12 members.
moved a representation on 9/12/2024, expressing no confidence in the petitioner. Full stop. It is a case of the petitioner that the notice of no confidence was issued by the respondent number 3 on 20/12/2024, proposing to hold a meeting on 4/1/2025. Full stop. Being agreed by the said notice of no confidence, the petitioner is before this court. Next para. The learned counsel for the petitioner contends that Rule 3.1 of the Karnataka Gram Swaraj and Panchayat Raj Act, Panchayat, what is the name of the
Gram
rules?
Swaraj Act.
Karnataka Gram Swaraj and Panchayat Raj Act,
1993.
no confidence motion against President, Adhyaksha and Upadhyaksha rules.
49. Rule.
Rules 2020.
Rules 2021 na?
2020.
2020 mandate a 15 days clear notice to be issued to the petitioner. She submits that if a thing has to be done in a particular manner, it has to be done in that manner alone or not at all. She also submits that this 15 days notice is provided so as to enable the petitioner to convince the members not to proceed with the no confidence. Full stop. Therefore, she contends that this provision of law is mandatory and non-compliance of which should vitiate the proceedings. Full stop. This is, however, contested by the learned counsel for the respondents, private respondents who contend that the procedure prescribed contends that the notice period of 15 days prescribed under Rule 3(1) is not mandatory but directory. Full stop. He contends that no prejudice is caused to the petitioner by holding the no confidence motion on the 15th day. Full stop. In support of his contention, he relied upon the judgment of a coordinate bench of this court in the case of Venkatram and other sources assistant commissioner. Full stop. Next para. A full bench of this court, do you have that copy, madam?
I'll produce.
Full bench of this court in the case of so and so, while considering the question whether Rule 3(1) of the Karnataka Gram Swaraj and Panchayat Raj Act, Panchayat Raj, bracket, no confidence motion against Adhyaksha and Upadhyaksha Rules 2020, categorically held that the procedure prescribed is mandatory. Full stop. This court also noticed the purpose of providing 15 days notice and held that the non-compliance of this mandatory provision should result in vitiation of the no confidence motion. Full stop. Therefore, full stop. As rightly contended by learned counsel for the petitioner, since the notice of no confidence is dated 20th of December 2024 and the proposed meeting was on 4/1/2025, the notice was in clear violation of Rule 3(1) of the Rules 2020. Consequently, the notice of no confidence issued against the petitioner deserves to be interfered with. Full stop. Consequently, this writ petition is allowed and the impugn notice issued to the petitioner proposing to hold the no confidence motion against her on 4/1/2025 is quashed. However, it is open for the private respondents to initiate fresh proceedings against the petitioner in accordance with law. Full stop. Next para. Before parting from the case, this court has noticed a tendency on the part of the assistant commissioners who deliberately fix the meeting before the expiry of 15 days. Full stop. The case on hand is one such case where the assistant commissioner, though knowing fully well that there was no clear 15 days notice between 20/12/2024 and 4/1/2025, has fixed the meeting on 4/1/2025. Full stop. This has resulted in avoidable expenditure to the state, loss of time and involvement of men and machinery for the aforesaid purpose. In that way of the matter, the respondents 1 and 2 are directed to initiate suitable action against the respondent number 3 for deliberate against the respondent number 3 respondent number 3 and also recover the costs incurred in the process for holding the meeting on 4/1/2025 from the respondent number 3. Full stop. The respondent number 1 and 2 shall keep the court informed about the steps taken against the respondent number 3. Yes.
Please. Much.
The judgment is already discussed in Sharda Bai's case. Even Venkatrama's case is
whatever it
because
is,
they.
all right. ತೆಗೆದುಕೊಡಿ ಅದನ್ನ ಯಾವ್ದು.
Please.
You should come up with, ಹಿಡ್ಕೊಂಡ್ ಬರ್ಬೇಕಲ್ಲ, ನೀವೇ ಅಪಿಯರ್ ಆಗಿದ್ದ ಕೇಸಲ್ಲಿ. ಯಾವ್ದೋ ನೀವು ಅಪಿಯರ್ ಆಗಿದ್ರಲ್ಲ, ಯಾವ್ದೋ I don't remember, but you appeared in one case.
Yes.
Hmm. Yes.
Please. My lord,
Lordship,
yeah, after conversion of my land, my lord, the approve the layout.
What
While
after
approving the
subsection
layout,
number
but-
2,
Sorry.
petitioner name to be clarified as per the representation
Objection.
dated so and so.
Oh, her son has filed the,
Huh?
her son has signed the request letter, requested the authorities. That is only request letter.
Annexure G. You are the owner of this property.
Yes, my lords, the land was converted to, from agriculture,
After
non-agriculture.
subsection C number 2 is overruled. Yes.
Then the layout is also approved by demarcating the civic committee site and garden area. You also kindly see annexure C. I have produced that approval of layout
Hmm.
in phase 13, my lords.
Hmm.
That which is reserved for garden and civic committees. Now they are constructing the toilets, public toilets, 6 and 7.
Civic
It will affect
committees-
the public toilets will not include the civic committee and garden area. It will entire my layout will lost its value and beauty also. Let them construction some other area which is in the belongs to government. To reserving these plots, my lord, only to garden and other civic committees.
Even if it's a garden, there should be a toilet, isn't it?
God, small tents, it's only for the who are visiting the garden, that is
Oh,
different, my lord. Public toilets, my lord, that is for the entire village peoples.
Yaar government yaar. Who applies for the respondents?
Respondent, my lord, Jilla Panchayat Kalaburagi, Deputy.
ಯಾರು? ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಕಲಬುರ್ಗಿ ಯಾರಿದ್ದಾರೆ? ಪ್ರಶಾಂತ್ ಕುಮನ್. Rupasagar Patil. AG is directed to accept notice for response 1 and 2. What about assistant project director? ನೀವೇ ಇದ್ದೀರಲ್ಲ?
Our. Yes.
1, 2 and 4.
urban development.
Mr.
2 and
Rupasagar Patil is directed to accept notice for respondent number
Deputy
3.
Commissioner.
3, 5, 6,
and
7.
ಇದು AGA for 5 and 8 ಅಂತ ಮಾಡಿ. Sorry, 1,
SCGP.
2, 4 and 8. Rupasagar for 3, 5, 6, 7.
And 7. Interim order, my lord, otherwise they will put up a construction, it is very difficult for them to demolish. If the entire public toilet is built in the entire garden area.
You're not residing there.
Not plots, my lord, they have prepared, the layout is approved.
ನಿಮಗೆ ಸೈಟ್ ಕೊಟ್ಟಿದಾರಾ?
Site nanal, I am the owner of the land and I am,
You are the owner of the land.
yes, my lord. Layout is approved.
Hmm.
Now the which is reserved for that garden, my lord, now they
You
are,
executed a relinquishment deed in respect of the CA site.
if,
CA site ಬಿಟ್ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅಲ್ಲ ಬಿಟ್ಕೊಡ್ that is a procedure, my lord, but if we ಬಿಟ್ಕೊಟ್ರು now they can't construct the public toilets.
Right, madam, ಬಿಟ್ಕೊಟ್ಟಿದ್ದೀರಾ?
ಅದು instructions ಇಲ್ಲ.
ಕೊಟ್ಕೊಡಿ ಅದನ್ನ ಫಸ್ಟ್.
Yes. Till the, ಅಲ್ಲ ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡೋದಕ್ಕೆ ಪ್ರಾಬ್ಲಮ್ ಇಲ್ಲ. Let them not to construct these.
ಎಕ್ಸಿಕ್ಯೂಟ್ ಮಾಡಿ ಲೇಔಟ್ ಅಪ್ರೂವಲ್ ತಗೊಂಡಿದಿರಲ್ಲ,
ಹಾ.
ಈ CA ಸೈಟ್ ಪಂಚಾಯತಿ ಬಿಟ್ಕೊಡಿ.
ಅಲ್ಲ ಬಿಟ್ಕೊಡ್ತಾರೆ ಅವ್ರು, it's not in, but they have not, they can't construct these big toilets in the garden area.
Subject to the petitioner executing a deed of relinquishment, relinquishing the area reserved for civic community and garden area in the layout plan as per annexure C, comma, the respondents
6 and 7, my lord.
6 and 7 are restrained from, within relinquishing the garden area and civic community and the area reserved for civic community sites in the layout plan at annexure C within 15 days from today, comma, the respondents 6 and 7 are restrained from putting up any restrained from constructing any toilets in the civic community area.
Yes, ma'am. In the said survey number 232.
Civic community area in the land bearing survey number
232. Sulepet
232 of
Sulepet village.
Sulepet village, Chincholi Taluk, Gulbarga district, measuring 2 acre 39 guntas. Full stop. It is made clear that if the petitioner fails to execute the relinquishment deed as stated above within 15 days, comma, the respondents shall be at liberty to recover possession of the civic community area as well as the park area and cordon it off by a fence and display that the property property belongs to the respondent number 6 and 7, respondent number 7. Yes,
Instead of 30 days haki alle formalities irtavadella affidavit they have to.
within 30 days. Something.
Yes, ma'am.
Arun Kumar. Council submission with regard to office objection number 7.
Your Lordship, annexure C is the manuscript of the order sheet of the OS 195. So kindly dispense for the time being, Your Lordship.
The office objection, serial number 27 is
Typed
overruled by
copy.
accepting the submission of the learned counsel for the petitioner. Yes, what is the case?
Your Lordship, a case is filed for a partition and separate position by the plaintiff.
Ah,
And when the case is posted for DW1, cross of the DW1, IN 19 and 20 has been filed. As it was, the DW1 was taken as nil. So plaintiff has filed IN number 19 under section 151 to set aside the order 22/7/24 for permitting to further cross-examination. And then IN number 20 under order 18, rule 17, again, it was filed to recall the order to permit for the further cross-examination, which was dismissed by the trial court, Your Lordship. As a part of cross-examination has been conducted by the plaintiff, Your Lordship. But afterwards, due to some personal reasons, the cross was not conducted for further. So it
suit
was,
is for partition.
yes, partition and separate possession. Your Lordship.
2012 suit, yavaga?
It's 2012. Your Lordship.
PWN is present, you are continuously sought for time. Cross of DW1, cross of DW1, there dictate.
Sir, in 26/10/2023 only the DW1 has filed a
That is
GP.
right, but how many opportunities was given to you?
Yes, Your Lordship. Opportunities were given and in some occasions DW1 was absent. Your
Please come to page 106. DW1 is present, cross-examined in part by plaintiff's counsel. He prayed for time, further cross of DW1 by 26/3. 26/3 DW1 absent. 8/4 DW1 present. Praise for time. 27/5 DW1 present, praise time. 6/6 cross-examination DW1. 22/7 DW1 present, praise time, no grounds. In ಎಷ್ಟೊತ್ತಿ opportunity ಕೊಡ್ಬೇಕು?
Final opportunity may be given, Your Lordship, as the next date is tomorrow, Your Lordship.
Issue emergent notice In addition, learned counsel for the petitioners
The notice has to be given to only
directed to serve the learned counsel who represented the respondent number 1. DW1 yaru?
D9, defendant number 9, Your Lordship.
DW1 is defendant number 9.
Yes, Your Lordship.
Shankaramma.
Yes, Shankar.
Issue emergent notice to respondent number 9.
9.
Full stop. Issue emergent notice to respondent number 9. In addition, the learned counsel for the petitioners is directed to serve the learned counsel who represented the respondent number 9 before the trial court. Notice to the other respondents is dispensed for the present. Full stop. Interim stay of further proceedings till the next date of hearing. List on date code. Sanjay Kumar.
I filed an application for impleading. He's a,
ಹೋಗಿದ್ಯಾ?
ಹೋಗಿಲ್ಲ some.
To notice on IA 1 of 24. IA 3 of 24 direction, IA 4 of 24 for additional documents.
Need about 10 days time, my lord, kindly to
IA 3 of
do the process,
24
ma'am.
and IA 4 of 24 in serial number 21 would be considered along with the main petition. Similarly, IA 4 of 24, IA 5 of 24 would be considered along with the main petition. List on, when do you want it?
Date.
ಯಾವಾಗ ಬೇಕು?
After 2 weeks.
After 2 weeks.
Yes.
ಸರಿ ತಿಳ್ಕೊಳ್ಳಿ ಯಾವತ್ತು ಬೇಕು ಅಂತ ಮೇಡಮ್ ಇದ್ರಲ್ಲ ಈಗ. Examination matter is ಯಾವ್ದು education matter.
Yes, ma'am.
Education.
You want it after 2 weeks.
Yes, ma'am.
List after 2 weeks and date put.
Yes.
ಅದು ಫೈಲ್ ಓದಿದ್ದೀರಾ? Have you read the file? ಓದಿದ್ದೀರಾ? ಯಾಕೆ? ಫೈಲ್ ಓದ್ಬೇಕಲ್ಲಮ್ಮ. ಫೈಲ್ ಓದಿದ್ರೆ ಎಷ್ಟು ತಿಳ್ಕೊತೀರ ನೋಡಿ. ಒಂದು ಡ್ರಾಫ್ಟಿಂಗ್ ಮಾಡೋದು ಹಿಂಗೆ, ಒಂದು ಪಿಟಿಷನ್ ಡ್ರಾಫ್ಟಿಂಗ್ ಮಾಡೋದು ಹೆಂಗೆ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ. ನಿಮ್ ಸೀನಿಯರು ಯಾವ ರೀತಿ ಇದನ್ನ ವಿಮರ್ಶಿಸಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ. ಏನೇನ್ ಗ್ರೌಂಡ್ಸ್ ತಗೊಂಡಿದ್ದಾರೆ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ. ಏನ್ ಪ್ರೇಯರ್ ಕೇಳ್ಬೋದು ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ. ಯಾಕೆ ನೀವು ಓದಲ್ಲ?
I'll go through it, madam.
Make it a point from tomorrow onwards. Whatever file is given to you, you should read. Whatever file is given to you, you should read. That is how you learn. Please cultivate that habit.
Sorry.
Yes. Yes, next. 22.
20.
Last time, for suggesting name. Only one.
ಅದೇನು ಹೇಳು, ಗೊತ್ತಾಯ್ತು ಯಾರಾದ್ರು?
Though yes, consultant was previously working at district judge as a district judge, my lord. Now he is consultant for Mohammad Khan Patan, my lord.
Mohammad Khan Patan.
He was though is but he is regular to the Kalaburagi test. One of the district judge contacted him, my lord, yesterday and informed him, and he consulted for. I informed him today is not.
Wonderful. The petitioners have challenged the allotment of work, allotment of certain public works by the respondent number 3 to 5 to the respondent number 6 and 7 without following the due process of law. They also submitted representations dated 14/2/2024 to the respondents 1 and 2, bringing to their notice the illegality in the allotment of work, public works to the respondent number 6 and 7, and have sought for allotment and have sought for cancellation of the said allotment and to take action against the respondents 3 to 5. Full stop. Next para. The petitioners contend that they are qualified they're qualified contractors. This content, they are qualified contractors for execution of work petitioners contend in new scheduled caste and scheduled tribe ನೀವು
Yes, madam.
petitioners contend that they belong to scheduled caste and scheduled tribe respectively and are registered as contractors with the Department of Panchayat Raj. Full stop. They contend that the respondents 3 to 5, without following the guidelines and the provisions of the Karnataka Transparency in Public Procurements Act, have allotted substantial public works to the respondent number 6 and 7 and have thereby deprived eligible contractors such as the petitioners from participation. Full stop. They also allege that they had brought the notice of this illegal allotment of works to the respondents 6 and 7 to the notice of the respondents 1 to 3 and they had requested the response 1 to 3 to forthwith cancel the allotment of work and to initiate suitable action. Full stop. Since the response 1 to 3 have not taken any action in this regard, the petitioners are before this court. Full stop. This court, in terms of the order dated, order sheet. This court, in terms of the order dated 25/7/2024, noticed a prima facie case. Notice, held that there was a held that the issue required further consideration and therefore restrain the respondents 1 to 3 from processing any bills of the respondents 6 and 7 for payment until disposal of this writ petition. Next para. The respondent number who has filed the statement?
1, 2, 3 and 4.
The respondent number 1 to 3, sorry, the learned AGA representing the respondents, representing the respondent number 5, has filed a statement of objections containing inter-alia ನೆನ್ನೆ ಏನೋ ತೋರಿಸಿದ್ರಲ್ಲ ಎಲ್ಲಿ ಅದು
Para 5,
Para-
madam. Para 5, my
Five.
lord. All the
containing inter alia
by oversight.
that out of 36 works, 21 works was reserved for scheduled caste and 15 was reserved for scheduled tribe. Full stop. It was contended that due to oversight, some works which was reserved for scheduled caste was allotted to general category, and the same was compensated by allotting the work to a person belonging to the scheduled caste. Likewise, they have referred to various instances of allotment of work to persons belonging to belonging to general category. Full stop. It therefore appears that something is amiss in the functioning of the respondents 6 and 7. And the respondents 6 and 7 have misused their power in conferring largesse on a person who was not entitled to apply. Full stop. The respondents 6 and 7 have also not complied with the guidelines issued by the respondent number 3, na?
CO, madam.
By the respondent number 4. By the respondent number 4. But have bifurcated the works according to their whims and fancies and have allotted the works to the respondent number 6 and 7. Full stop. Since this issue needs a deeper examination, this court considers it appropriate to appoint Mr.
Mohammad Khan M. Patan.
Mohammad Khan M. Patan to inquire into the way in which these works were allotted by the respondent number
6 and 6.
where is allotted to the respondent number 6 and 7. Full stop. He shall also report the illegalities committed in the allotment of the works to the respondent 6 and 7. Full stop. It is open for the respondent 6 and 7 to participate in the inquiry. Full stop. The Mr. Mohammad Khan Patan, retired district judge, shall inspect the records of the respondent number 3, 4, and 5.
Yes,
3, 4, and 5 on January 23, 2024.
25.
And submit a report to this court by 19th February 2025. Full stop. The fee for conducting the inquiry is tentatively fixed at a sum of rupees 1 lakh, which is payable by the respondents 3, 4, and 5. By or before 19th February 2025. Full stop. Issue suitable notice to Shri Mohammad Khan Patan, retired district judge, and also enclose a copy of this order for his information. Full stop. It is open for the respondent 6 and 7 to also be present on 23rd of January 2025 at the office of the respondent number 5. At the office of the respondent number 5. and assist him in finalizing his report. It is made clear that no fresh notice would be issued to the respondent 6 and 7. Full stop. Yes, list on 21st of February 2025 for report of report of Shri Muhammad Khan Pathan. Mr. Shiva Prasad Shantan Gaurav.
Milords, appearing for the petitioner. Milord, this matter pertains to, Milords, the petitioner is the principal of an Ayurvedic college
Ah,
run by the trust, Milords, of which respond number 2 is the president.
ah.
Now, Milords, respond number 2 has expired. Milords, during the pendency of this petition.
Now, how can the president expire?
Milord, what has happened is there is no new trust meeting held, convened, and no new president has taken charge yet because of the dispute between the trustees. Milords, what has
So
happened?
What happens? What does your bylaw provide for?
In the
Milord, they
absence
have
of to-
president, vice president will be the,
What does the trust deed provide for?
yes,
Milord,
kindly look at page, Milord,
Vice President yaru?
vice president, the third respondent herein is the vice president.
which has been implemented, Milord.
Kindly, Milord, with my statement of objections, I have filed, trust
Milord.
deed, the copy hakidini,
Ah,
trust deed, the internal page, 4 nodri sahebre.
ah,
Powers and duties of the president and vice president.
ah.
The president shall preside over all the meetings of the board and shall look after control the day by day affairs and function of the trust.
Hmm.
The vice president shall function in the absence of president with the same powers as that of the president.
Yes.
Milord, Milords, that is one aspect of the matter, but Milords, the grievance in this case is, Milords, the bank, respond number 1 bank, has freezed the account of the principal of Milords, principal of the Ayurvedic college. And the reasons assigned, Milords, is at page number 34, annexure D. Milords, you got it, Milords?
Just a moment.
Due
Who
to
are you?
certain,
Who are you?
Milords, I am the principal of the college, which is run by the trust, Milords.
How can you challenge the trustees themselves?
Milords, I'm not
That is one
challenging
of the
that aspect of the matter, Milords. My grievance, cause
Now
of
the
action arose,
vice
Milords.
president will, correct, Mr. Now the vice president will decide how the trust will run.
No, Milords, that is not the question, Milords. Here, my account, the principal's account was freezed by the bank due to certain disputes between the trustees, because of which I could not give salaries to the faculty and teaching and non-teaching faculty. Because of this reason, this Honorable Court passed a detailed interim order, Milords, on 11/9/2024.
Ah.
And this Honorable Court held that
May I give a
starting from the month
clear
of
picture?
Just one nimsham,
I,
one after the other. I am not in a
Parole.
hurry.
just to assist, I say.
From the month of August onwards, Milords, I was directed to pay, the bank was directed to release the payments to the teaching faculty as per the affidavit which was filed by me, stating that I will undertake to only utilize the funds for payment of salaries. However, it was the direction was given that prospectively the payments would be made. At paragraph number 9, Milords, would be relevant.
No, the writ petition itself can be disposed of.
Please, my lords, but the only thing left, my lords, is it since the order was only operating prospectively from the month of August, there are certain arrears of salary which needs to be paid. Therefore, my lords, on the last date of hearing, the coordinate bench, my lords, directed that to see whether there is any possibility of a settlement between the trustees, so everything would be sorted out.
So far as the salary payable to the staff,
We have no objection as far as payment of salary is concerned. What is the point is, what we are requesting, let our joint signature of now I am the president. My signature with that of the petitioner. That's all we are seeking.
yes.
Submissions.
For payment of salary to the employees, we have no objection.
You file
What?
you file an affidavit
Please.
that henceforth you will not have any objection to pay the salary
Ah.
to the staff.
To the staff.
And also whatever arrears that are.
ಅಲ್ಲಲ್ಲ arrears ಇರಲಿ ಸಾಹೇಬ್ರೆ, ಈಗ about the salary, the only point what we are agitating is what here.
ನೀವು ಜಾಯಿಂಟ್ ಸಿಗ್ನೇಟರಿ ಆಗ್ಬೇಕಷ್ಟೇ.
ಅಷ್ಟೇ, ಮೊದಲು ಜಾಯಿಂಟ್ ಸಿಗ್ನೇಚರ್ ಇತ್ತು ಸಾಹೇಬ್ರೆ. ಮೊದಲೇನಿತ್ತಂದ್ರೆ ಸೆಕ್ರೆಟರಿ ಕಮ್ ಪ್ರಿನ್ಸಿಪಾಲ್ ಇತ್ತು ಈ ಅಕೌಂಟಿಗೆ. ಈತ ಏನ್ ಮಾಡಿದಿತ್ತು ಸೆಕ್ರೆಟರಿ, he usurped the post of the principal, ಇದ್ದ ಪ್ರಿನ್ಸಿಪಾಲ್ ನ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂತ ತಿಳಿದು ಮಾಡಿಕೊಂಡು.
ಆಯ್ತು, ಅಂದ್ರೆ ಎಷ್ಟು ಅಕೌಂಟ್ ಇದೆ? How many accounts you have?
Accounts are there.
There are two accounts.
Two accounts.
So two accounts ಅಲ್ಲಿ ಪ್ರಿನ್ಸಿಪಲ್ ಮತ್ತೆ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್
ಇಲ್ಲ, ಒಂದು ಅಕೌಂಟ್ ಏನದ, ದಿ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಅಂಡ್ ಸೆಕ್ರೆಟರಿ.
Submissions, submissions. Since I am representing for.
ಸೆಕ್ರೆಟರಿ ಅಂಡ್ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್, ದಟ್ ಈಸ್ ದ ಮೇನ್ ಅಕೌಂಟ್ ಮೇಲೆ. ಇದು ಒಂದು ಪ್ರಿನ್ಸಿಪಾಲ್ ಹೆಸರಲ್ಲಿ ಯಾಕೆ ಅಕೌಂಟ್ ಮಾಡಿದ್ವಿ ಅಂದ್ರೆ, ಇವು ಎಕ್ಸಾಮಿನೇಷನ್ ಫೀಸ್ ಕಳ್ಸೋದಿರ್ತದೆ ಯೂನಿವರ್ಸಿಟಿಗೆ, ಯೂನಿವರ್ಸಿಟಿ ಅವ್ರ ಸ್ಕಾಲರ್ಶಿಪ್ ಕೊಟ್ಟದ್ದು ಬರ್ತಿರುತ್ತೆ ಅಂತ ಹೇಳಿದ್ರೆ, ಇದು ಒಂದು ಪ್ರಿನ್ಸಿಪಾಲ್ ಹೆಸರಲ್ಲಿ ಒಂದು ಅಕೌಂಟ್ ಮಾಡಿ, ಅದು ಮೇನ್ ಟ್ರಸ್ಟ್ ಹೆಸರಲ್ಲಿ ಅದ, ಸೆಕ್ರೆಟರಿ ಅಂಡ್ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಜಾಯಿಂಟ್ ಸಿಗ್ನೇಚರ್. ಇದು ಇದ್ರ ಪರ್ಪಸ್ ಮಾಡಿದ್ವಿ ನಾವು. ಇದು ದಿಸ್ ವಾಸ್ ಬೀಯಿಂಗ್ ಆಪರೇಟೆಡ್ ಬೈ ಸೆಕ್ರೆಟರಿ ಅಂಡ್ ದ ಪ್ರಿನ್ಸಿಪಾಲ್ ಜಾಯಿಂಟ್. ಇದು ಆಲ್ಮೋಸ್ಟ್ ಫ್ಯಾಮಿಲಿ ಟ್ರಸ್ಟ್ ಮೇಲಾಡ್. ಇವರು 5 ಜನ ಯಾರಂದ್ರೆ, ದಿ ಪ್ರೆಸಿಡೆಂಟ್ ಈಸ್ ದಿ ಫಾದರ್ ಆಫ್ ದ ಪಿಟಿಷನರ್ and father-in-law of this respondent. My father-in-law, father of the president, father of the petitioner. Innobru, brother-in-law of the petitioner. Matte ನನ್ನ ಫಾದರು 5 ಜನ ಇದ್ರು. ಈಗ ನಮ್ಮ ಫಾದರ್ ತೀರ್ಕೊಂಡ್ರು. ನಮ್ಮ ಫಾದರ್ ಅವರು ಮೊನ್ನೆ ತೀರ್ಕೊಂಡ್ರು. ಇದು ಅಡ್ವಾಂಟೇಜ್ ತಗೊಂಡು he started misusing ಯಾರ್ ಸೆಕ್ರೆಟರಿ. Then we gave a complaint to the bank stating that e account ಏನದ joint signature of the principal and secretary ಅಂತ ಹೇಳಿದ, the person in question who is one of the trustee, he has usurped the power of the principal, and my lord, without there being any resolution etc., he writes to the bank stating that I have become the principal.
ನಿಮ್ ಟ್ರಸ್ಟಿ ಪ್ರಕಾರ who has to operate the bank accounts?
ಮೊದಲಿನ ಪ್ರಕಾರ ಅಂತ ಹೇಳಿದ್ರೆ ಪ್ರಿನ್ಸಿಪಾಲ್ ಅಂಡ್ ಸೆಕ್ರೆಟರಿ.
Principal and secretary.
Yes.
You are not the secretary.
I am not the secretary.
Who is the secretary?
Petitioner, ಈಗ he has become the principal.
He is the principal.
ಇಲ್ಲ, he was the secretary, my lord. He was not the principal. What he does, ಇದ್ದ ಪ್ರಿನ್ಸಿಪಾಲ್ಗೆ ಡಿಮೋಟ್ ಮಾಡ್ತಾನೆ. ನೀ ವೈಸ್ ಪ್ರೆಸಿಡೆಂಟ್ ಆಗಂತ. He cannot use the principal. He makes him as a vice principal and he himself becomes the principal. ಯಾರು ಸೆಕ್ರೆಟರಿನೇ.
ಪ್ರಿನ್ಸಿಪಾಲ್ ಇಲ್ವಾ ಅಲ್ಲಿ?
He is claiming to be principal. ಬೇರೆಯವರಿಲ್ಲ.
ಮತ್ತೆ ಸೆಕ್ರೆಟರಿ ಯಾರು?
ಅದನ್ನೇ.
ಅವನೇ ಸೆಕ್ರೆಟರಿ ಪ್ರಿನ್ಸಿಪಲ್ ಇಬ್ರು ಹೆಂಗಾಗುತ್ತೆ?
That's what.
Milords, one submission, Milords.
His pleadings are that.
Milords, what has happened in this case, there are much more complications. There is a case and counter case. FIR has also been registered for physical assault. Milords, what I request is, I will propose a solution. A final coitus can be laid. 2 weeks, any convenient date may be given, Milords. We'll propose a solution.
Please take a date which is convenient to you, within
Please.
which you can put a coitus.
Please, Milords.
ಇದರನ್ನೇ ಹೇಳೇ 3 ಡೇಟ್ ತಗೊಂಡ್ರ.
Finally,
ನಮ್ಮ ಜೊತೆಗೆ ಒಂದ್ಸಲನು ಮಾತುಕತೆಗೆ ಸಹಿತ ಬಂದಿಲ್ಲ, ಫೀಲರ್ಸ್ಗೂ ಕಳಿಸಿಲ್ಲ ಅವರು.
ಮತ್ತೆ ನೀವು ಯಾಕೆ why are not taking steps to resolve the dispute?
On 27th, Milords, matter could be closed, Milords. I would.
The learned counsel for the petitioner submits that the dispute relates to The dispute relates to operation of a bank account of a trust constituted.
Bank account of the college.
College.
Bank account of a college established by a trust constituted amongst members of a family. Full stop. He submits that the petitioner is trying to explore a settlement between the parties and therefore seeks time. Full stop. The learned counsel for the respondent number 3, respondent number 3 submits that the petitioner has not made any attempts towards a settlement of the
To reach
dispute.
out, to reach out.
Full stop. In that way of the matter, as a last chance list on 20.
7th.
ಅಲ್ಲ ಬಹಳ ದೂರ
27th.
ಆಗುತ್ತೆ ಅವರು ಅಮೌಂಟ್ ಮಿಸ್ಯೂಸ್ ಮಾಡ್ತಾರಂತ ಅನ್ನೋದು ಅಷ್ಟೇ ನಮ್ಗೆ.
My lord,
Misuse
there is an
or
affidavit filed, my lord.
Court has said you can only pay salaries, nothing else.
ಅದೇ ಅದೇ
So misuse
ಅದ್ರಾಗ ಏನಾಗಿದೆ ತಾನು ಸ್ವಂತ ಸ್ಯಾಲ್ರಿ 1.5 ಲಕ್ಷ ತಗೊಳಕೈತೇನ 5 ಜನ ಎಂಪ್ಲಾಯೀಸ್ ಇಲ್ಲ ಐ ಹ್ಯಾವ್ ಫೈಲ್ಡ್ ಐ ಆಲ್ಸೋ ಅವ್ರದ್ದು ಸ್ಯಾಲ್ರಿ ತಗೊಳಕೈತೇನ ಇದು ಆಗತ್ತಂತ ಅಷ್ಟೇ ನಮ್ಗೆ.
Yes, yeah. List on 27th January 2024.
Please.
Mister, you don't draw any salary as the principal.
ಮತ್ತೆ and the 5 employees who are not on the ಇದು.
Please, my lord.
I think employees irli, but you don't draw any salary
Yes.
Please,
till the
my lord.
next date.
Please.
Stop. In view of the peculiar facts of this case, and the contention of the learned counsel for the respondent number 3, that the petitioner taking advantage of the interim order granted by this court on
11/9/2024.
11/9/2024, the petitioner is trying to withdraw amount in his name, it is appropriate that the petitioner is directed not to draw any amount from the account of the college in his name till the next date of hearing. Yes.
Much.
Not to withdraw but not to withdraw. Yes. See number 24.
Hearing for the petitioners.
Any
Petitioner has filed
objection
a.
to allow this application?
Yes, please.
IA 124 is filed to amend the writ petition. The learned counsel for the respondent number 4 fairly does not object to this application. Even otherwise, since the amendment sought for is necessary for the purpose of considering the writ petition, IA 124 is allowed and the petition is permitted to amend the writ petition and file an amended writ petition within 1 week.
Date may be.
List down date. Sandeep Vijay Kumar.
7th.
Yavat ಬೇಕು.
There is
Sandeep
interim
Vijay-
order operating.
Interim order granted release extend till the next date. Sandeep Vijay Kumar, Ganesh Naik.
Appearing for the respondent.
Appearing for the petitioner's counsel, my lord. Lord,
Yeah, what is
short day, my lord, 1 week's time just now they have.
Time ಬೇಕಾ?
But
1
the
week.
Check to result of writ petition ಅಂತ ಮಾಡಿದ್ದಾರೆ ಸುಮ್ಮನೆ no confidence motion ಆಗಿದೆ but still other
Subject to
proceedings
result
ಇಲ್ಲ.
of the petition ಅಂತ ತಿಳಿದಾಗಿದೆ.
ಆಯ್ತು ಇವಾಗ 49(2) ಎಲ್ಲ ಇಲ್ವಲ್ಲ ಈಗ. So therefore, where is the question of allegation ಅದೆಲ್ಲ ಇಲ್ವಲ್ಲ. Specific allegation ಎಲ್ಲ ಇಲ್ವಲ್ಲ ಅದು. It is not in force now. 49(2) is not in force.
A week's time.
But it is the
Learned counsel for
further
the petition.
proceeding ಮಾಡಕ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರೆ
ಆ?
further proceeding ಮಾಡಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ರೆ ಆಗುತ್ತೆ.
ಆಯ್ತು ಒಂದು ವಾರದಲ್ಲಿ ಏನಾಗುತ್ತೆ?
ಆಲ್ರೆಡಿ ಮಲೋಡಿ ಇದಕ್ಕೆ ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಮೋಷನ್ ಆಗಿದೆ 18 ಜನ.
ಯಾವತ್ತು ಅವ್ರಿನ್ನ ಏನೋ ಓದಿಲ್ಲ ಅಂತ ಅವ್ರು.
ಅಲ್ಲ ಇದ್ರದ್ದೇ ಸಬ್ಜೆಕ್ಟ್ ಟು ರಿಸಲ್ಟ್ ಅಂತ ಇಟ್ಕೊಂಡು ಅವರು ಇದು
16th
ಮಾಡ್ತಿದ್ದಾರೆ.
Learned counsel for the petition seeks time as a last chance list on 16th.
16th.
Prakash Jadhav.
My lord, I am appearing behalf of the petitioner in this case, my lord. I am seeking a week time, my lord. I will comply the court order, my lord. Earlier order, my lord.
What court order?
My lord, this honorable court directed to me, they serve the copy to the respondent. So till yet we are not a served. So therefore, we will be served the copy. Kindly have this matter in next week, my lord.
This is departmental inquiry.
Yes, my lord. This is a departmental inquiry. We have challenged that is the GO issued by the state government. This is this against to the section contrary to section 8A, 81A and 2D of the Karnataka Lokayukta Act 1984, my lord. So already department inquiry petitioner was exonerated in the department inquiry. Subsequently, he was approached to this honorable court. This honorable court is a liberty reserved to the respondent. He was once again approached to the authority. Authority is exonerated, and subsequently he was filed the Lokayukta case against the petitioner.
Counsel for the petition seeks time.
Issue notice to the respond number 1 and 5, your lordship.
Who is R1?
Is the chief executive officer.
Who is R1?
R1 is the principal secretary department,
Take out.
rural. At least 5. R5.
Who is R5?
R5 is the government under secretary, deputy director and promotion department of the rural development.
Accept notice for R1 and R.
R1 and R5.
R1 and R.
Yes.
Counsel for the petition is directed to serve copies of the writ petition to the learned HCGP. List on date.
Please.
Much obliged, my lord.
Geeta Anna Rao.
My lords, this case pertains to regularization. The petitioner had previously approached this honorable court, and lordship was pleased to pass the order in this matter. And thereafter, while she made a letter for requesting compliance of the court orders, my lords, to consider her application for regularization, she found out that previously her name was placed before the state committee for regularization, in which her name was not considered. So she is challenging even that order.
And the objection.
Learned HCG, learned AG seeks time to file objections. List on. This for preliminary hearing in B group on date. Amir Hamza.
Obliged.
Put it. AJ is directed to accept notice for respondent number 1 and 2. 1, 2, 4, 5. ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಬೀದರ್ ಯಾರು? ಅಲ್ರಿ ನೀವು ಬರ್ಕೋಬೇಕಲ್ವ, ಹಿಡ್ಕೋಬೇಕಲ್ವ ಎಲ್ಲಾದ್ರೂ ಒಂದು ಲಿಸ್ಟ್ ಅಲ್ಲಿ. ಎಲ್ಲಿದೆ ಲಿಸ್ಟ್ ಅಲ್ಲಿ? ನೀವು ಬರ್ಕೋಬೇಕು. ಇವಾಗ ಎಲ್ಲಿ ಕೃಪಾಸಾಗರ್ ಬರ್ಕೊಂಡ್ರ ಈಗ? ಯಾವ್ದಕ್ಕೆ ಕೃಪಾಸಾಗರ್ ಯಾವ್ದಕ್ಕೆ? ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಕಲಬುರಗಿ ಬರ್ಕೊಳ್ರಿ ಒಂದು ಲಿಸ್ಟ್ ಅಲ್ಲಿ. ಬೀದರ್ಗೆ ಯಾರು? ಎನಿಬಡಿ ಫಾರ್ ಬೀದರ್? ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಬೀದರ್.
ಪ್ರಶಾಂತ್ ಕುಮಾರ್.
ಗೌರೀಶ್ ಕಾಶಂಪುರ.
ಪ್ರಶಾಂತ್ ಕುಮಾರ್.
ಪ್ರಶಾಂತ್ ಕುಮನ್. ಪ್ರಶಾಂತ್ ಕುಮನ್. ಜಿಲ್ಲಾ ಪಂಚಾಯತ್ ಬೀದರ್ಗೆ ಯಾರ್ರಿ? Prashant Kuman. Prashant S. Kuman is directed to accept notice for respondents 3. Respond number 3. Issue emergent notice to respond number 6.
My lord, interim order may be clear.
Interim order ಎಲ್ಲ ಕೊಡೋದಿಲ್ಲ. Yes, next. This ಇದಾ? Anganwadi.
Appointment, Anganwadi teachers appointment ಕೊಟ್ಟಿದ್ದಾರೆ sir.
No,
She is the not residence of the village sir.
no interim order. Yes, next. Ravi Chandra Jadhav.
My lord, I am appearing behalf of the petitioner in this case, my lord. We have challenged to the clause 11(1)(1). The government issued the notification regarding the Anganwadi appointment, wherein, my lord, the 30 days, the time is prescribed, that is a 30 days. In that 30 days included the government holidays. So therefore, my lord, we seeking that is excluded the government holidays and given an opportunity to do further how many government holidays of those days. So kindly see the petition number 31 of the petition, my lord.
Yes.
My lord, clause 11. ಆಯ್ಕೆ ವಿಧಾನ ಅರ್ಜಿ ಸಲ್ಲಿಸಲು ಕನಿಷ್ಠ 1 ತಿಂಗಳ ನಿಗದಿಪಡಿಸಬೇಕು. They fixed the date and the application started 10/10/2024 and ended 9/11/2024. wherein government holidays also is the 9 days, my lord. So that's why we are humble to request this honorable court kindly excluded those days.
So where's the question of excluding those days?
Because, my lord, there is the 21 days, as per the government guidelines, any other document seeking,
So all Sundays have to be excluded, is it?
no, my lord,
Even
my lord,
Sundays
in
have to
the, no,
ಒಂದು ತಿಂಗಳಂತ ಹೇಳಿರೋದು.
my lord, in Dasra holiday, those days in Dasra holiday, that's why the government has declared the holidays, public holidays.
Whether the government was also on holiday.
Yes, my lord.
ಯಾವಾಗ?
So that ಹತ್ತೇ ತಿಂಗಳೊಳಗಡೆ ದಸರಾ ಹಾಲಿಡೇ ಇದ್ದು ಸ್ವಾಮಿ, ಅದಕ್ಕಾಗಿ ಅದರಲ್ಲಿ ಏನಿದೆ 21 days 14 days ಅವ್ರ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ರಿಕ್ವೈರ್ಡ್ ಇದೆ ತಗೋಬೇಕಾದ್ರೆ. Kindly see the page number 55.
When was the notification issued? When was the notification issued?
My lord, notification issued on 3/12/2022, my lord.
3/12/2022.
So 22 earlier order, my lord. So the notification, they started the application is at 10/10/2024, my lord. That is Anganwadi Karyakartis.
So when is the date? What is the date of the notification? Recruitment notification date is 3.
My lord, kindly pass over the matter, my lord. I will clarify it. Much obliged, my lord.
Hema Kulkarni. Yes.
I appear for petitioner, my lord. Respondent is filed before the civil miscellaneous for restoring the OS number.
What is the suit for?
Suit for specific performance of contract, my lord. Matter was posted on 29/11/18 for chief examination by PW1, my lord. Respondent number 19 is counsel, both are absent, my lord. Matter was become non-prosecution of OS is dismissed for non-prosecution, my lord.
Yes.
Respondent number 1 is filed civil miscellaneous before senior civil judge Muddebeyar, my lord. The
Why is
civil
it dismissed?
miscellaneous
Why is it dismissed?
non-prosecution of
ನಿಮ್ಮ ಸಿವಿಲ್ ಮಿಸ್ಲೇನಿಯಸ್ ಯಾಕೆ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು?
OS ಅಲ್ಲಿ ಇದು ಅಲೋ ಆಗಿದೆ,
ಅಲೋ ಆಗಿದೆಯಾ? ಅದನ್ನ ವಾಟ್ ಇಸ್ ಯು ಆರ್ ದ ಡಿಫೆಂಡೆಂಟ್ ಇನ್ ದ ಸೂಟ್?
Yes, my lord.
Why have you challenged it?
They are mentioned in provision also wrong, my lord, and date also wrong.
Barcode. The defendant in OS number OS number 10/2017 on the file of so and so is before this court challenging an order dated 6/12/2024 on an application filed by the plaintiff under Order 9 Rule 4 of CPC and setting aside the order of dismissal of the suit dated 29/11/2018 and restoring the suit for consideration. Next paragraph. The suit in OS number 10/2017 was filed for specific performance of an agreement of sale purportedly executed by the defendants. Full stop. The suit was contested by the defendants, following which the trial court framed issues and set down the case for evidence. The plaintiff was examined. Plaintiff had filed his affidavit, had filed his examination in chief by way of an affidavit on 13/11/2018 and marked exhibits P1 to P24. Full stop. This case was then posted for cross-examination for further examination of PW1. Full stop. However, due to his default, But however, due to his default and the default of his advocate in appearing before the court, the suit was dismissed for non-prosecution. Full stop. The plaintiff then filed civil miscellaneous 3/2019 under Order 9 Rule 4 of CPC. Full stop. After service of notice of this application, the defendants filed their objections. Full stop. The trial court, after considering the contentions urged, and the evidence adduced on the said application, allowed the petition in terms of the impugned order. Full stop. The trial court, while doing so, held as follows. Para 18 copy mode. Full stop. Being agreed by the aforesaid order, the defendants are before this court. Next, for the learned counsel for the defendants learned counsel for the defendant number 1 contended that the plaintiffs had invoked a wrong provision of law and that there was no reason to recall the order dismissing the suit for non-prosecution. Full stop. He also contended that the plaintiff did not produce any documents to establish that she was prevented from sufficient cause, he was prevented from sufficient cause in appearing before the court to adduce further examination, further evidence. Full stop. Next, for a perusal of the impugned order shows that the petition was dismissed for non-prosecution in view of the non-appearance of the plaintiff to lead further evidence. Full stop. The plaintiff has claimed that he could not appear before the court on 29/11/2018 in view of his ill health. Full stop. The trial court has held that the contention urged by the plaintiff is not contention urged by the plaintiff that he was prevented from sufficient cause from appearing before the court is quite possible and therefore granted an opportunity to the plaintiff to contest the suit on merits. In that way of the matter, there is no error committed by the trial court in restoring the suit by recalling its order dismissing the suit for non-prosecution. There is no error warranting interference, hence the petition is dismissed. Yes. Yes, yes, Halali.
Sudhir Singh ಅವ್ರ ಹೆಸರು ತೋರಿಸಿಲ್ಲ. Not the Lord mandamus against the central government, the joint director, joint secretary.
Yeah, what is the mandamus sought for?
Lord, it is in pursuant to the order of this honorable court, my request was considered and for extension of time in implementing the IEM. And they passed it, my lord, the period spent in the court is not considered, that is to be excluding that may be considered, that's my main prayer. That's at annexure page
But then
70.
the government will have to consider, Lord, 30 days time is given, 1 year.
ಅಲ್ಲ ಅಲ್ಲಿ 1 year ಅದು ಇನ್ನ ಹೈಕೋರ್ಟ್ ನ ಪೆಂಡಿಂಗ್ ಇದ್ದಾಗ ವಾಟ್ ಎವರ್ ದ ಟೈಮ್ ಸ್ಪೆಂಟ್ ದೇ ಹ್ಯಾವ್ ರಿವ್ಯಾಲಿಡೇಟ್ ಅಂಡ್ ರೆಗ್ಯುಲರೈಸೇಷನ್ ದೇ ಆರ್ ಆಸ್ಕಿಂಗ್ ಫಾರ್
Government, DSGI.
ಸುಧೀರ್ ಸಿಂಗ್ ಬಿಜಾಪುರ್.
Sudhir Singh Vijapur is, office is directed to show the name of Mr. Sudhir Singh Vijapur. DSGI as the council appearing for the response 1 to 3 in the
Not the
cause list.
cause.
List on.
Day after tomorrow.
Date kodi yavatund. Yes, yes, Dikshit.
In this matter, I'm challenging annexure E, your lordships, the order of rejecting of my technical bid, your lordships. The issue is that I have qualified, I have submitted, I have furnished.
To go before the appellate authority.
Yes, your lordships. But the reason is when I have furnished all the documents, they have not they have rejected my technical bid. And further, when I ask them what is the,
So you have to go before the appellate authority. How do you overcome the appellate authority?
yes, Your Lordships, because of the unreasonableness that is done by the respondent authorities.
Authority ನೋಡಕ್ಕಾಗಲ್ವಾ?
Pardon, Your Lordships.
Can the appellate authority not examine?
Yes, Your Lordships. But the another issue is they are not giving me any details with regard to who is the successful bidder or whose bid has been accepted and the details regarding that. Your
Has the
Lordships.
financial bid been opened?
Yes, Your Lordships. Financial bid is opened, Your Lordships.
Opened?
Yes, Your Lordships.
They have finalized it?
My technical bid is rejected, Your Lordships.
Correct. Your technical bid is rejected, so your bid is also rejected.
Bid is also
So
rejected.
therefore, you are entitled to challenge it.
But, Your Lordships, because of the unreasonableness, I want to refer to a judgment of the Honorable Supreme Court, Your
Good.
Lordships.
Hmm.
In Jagdish Mandal, Your Lordships.
Hmm.
In the case of Jagdish Mandal versus the state of Orissa.
Hmm.
Para 19 of the judgment that I'm referring to.
Yes.
Your Lordships, judicial review of administrative action is intended to prevent the arbitrariness, irrationalness, unreasonableness, and bias and malafide. It is the purpose. Its purpose is to check whether the choice or the decision is made lawfully, and not to check whether the choice or the decision is sound. When power of the judicial review is invoked, the matter is relating to matter relating to tender or awards of contracts. Certain special features should be borne in mind. A contract is a commercial transaction evaluating tenders, awarding the contract of essential. Your Lordships, I will come to the relevant point, Your Lordships. Next para, Your Lordships. The tenderer or the contractor with the grievance can seek damages in the civil court. Attempts by unsuccessful bidder with the imaginary grievance would prefer. Further, Your Lordships, the court discusses about when shall it be when can writ petition be maintainable, wherein the court says that when there is a arbitrariness and unreasonableness and there is a bias, then a writ petition can be made maintainable, Your Lordships.
That is okay, Mr. There is a statutory remedy.
Yes, Your Lordships.
This tender is under the provisions of the KTPP Act. So therefore, you have to follow this procedure.
Please, Your Lordships.
There is a way to do it. File an appeal, come to the High Court.
Please, Your
You
Lordships.
say that you filed an appeal. Without considering the appeal, they're trying to finalize the tender. Adhan stay ಮಾಡಿ ಅಂತ ಕೇಳಿ.
At least a mandamus may be issued directing at annexure F, directing the respondents to consider my application at annexure F and give me the details regarding who is the successful bidder. That will help me to raise the grounds, because I have successfully.
My lord, now technical bid is completed. After financial bid only is successful bidder.
Correct. Financial bid open ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಿದಾರಲ್ಲ.
That is my instruction.
No. Are you sure that it is opened?
That is my instruction. I'll
Instruction ಅಲ್ಲ. Whether the instruction is sure.
I will seek the instructions once more.
What do you want?
Your Lordships, I'll seek for pass over, Your Lordships.
There's a way to do it, Mr. High Court 226 is not a remedy for all ills.
Please, Lordships.
Kulkarni Srinath.
Yes, my lord. I am appearing for the petitioner. Lord, the petitioner before your lordship is, my lord, is an elected corporator to the Vijaypur city corporation by the BJP political party ticket, my lord. My lord, on 9/1/2024, my lord, the election for mayor and deputy mayor was held, my lord. In addition, 4 standing committee members were also elected. But now, my lord, tomorrow, my lord, that is 8/1/2025, the term of the present mayor and deputy mayor, my lord, will come to an end, my lord. My lord, this petitioner, my lord, seeking a directions, my lord, to the second respondent to issue the calendar of events, my lord. Because, my lord, he would have should issue, my lord, 1 month prior to the due date of the term, my lord. The due is tomorrow, my lord, on 8/1/2025, the tenure will be over, my lord.
Yes.
But till today, the calendar of events has not been
Who is
issued by the second respondent, seeking directions before the.
Who is the answering respondent?
Second
respondent, my lord. These regional commissioner.
Section, my lord.
Around HCGP, AGA. drafted to accept notice for respondents 1, 2,
Now, one
and
is election commission.
electoral officer.
Yes, ma'am.
The issue, third, AG is directed to accept notice for respondent number 2 and 3.
2 to 5.
2 to 5, my lord, please.
Your Commissioner
Sorry,
Vijaypura.
2, 3
Vijaypura-
and 5.
2, 3 and 5.
5.
Vijaypura City Corporation advocate.
Well, I think for 1 and 3, Mr. Amresh Roja is there.
Amresh Roja.
Amresh Roja is directed to accept notice for R4.
Even for 1, he is appearing.
1 and 4.
1 and 4.
We learned AG is directed to accept, directed to secure instructions whether any calendar of events is issued for election of mayor and deputy mayor in view of the term of the incumbent mayor and deputy mayor coming to an end on 8/1/2025.
Please.
Just
20th.
Friday, my lord.
tomorrow.
Friday, ma'am.
Day after
Please,
tomorrow.
Thursday, my lord, please. My lord, interim order also I have sought, my lord.
What interim order?
My lord, seeking directions to the 5th respondent Tashildar, my lord, that to not to alter the voter list, my lord. My lord, the Tashildar, my lord, at annexure, may kindly peruse.
Voters
Annex-
list ಎಲ್ಲಿಗೆ ಬರ್ತಿದ್ದು?
My lord,
What voters list?
my lord, for the 22nd term, mayor and deputy mayor elections.
No, how does the voter list get altered?
My lord, may I produce a document, my lord? My colleague is there, my lord, which is document dated 2012-2024, my lord. It's a communication letter by one of the BJP political party corporator addressed to the Deputy Commissioner Vijaypur, my lord, third respondent.
Uh, 2012, what is this?
2012-2024, my lord. My lord, the opponent political party, my lord, they are insisting the 5th respondent Tashildar to include the 4 names as mentioned in the document, my lord, into a voter list who are not residents of the Vijaypur city, my lord. They are the elected MLCs from some other district. Not since they have a less majority of voters, my lord, they are insisting the 5th respondent to add these 4 names. Who are certainly not in the voters list, my lord, which is provided by the Tashildar itself, my lord. Now, I have produced the voters list at page number 24, my lord, which is given by the Tashildar himself, my lord. Now, my lord, the opponent political party, they are pressurizing the 5th respondent to add these names. But if they add these 4 names, my lord, certainly they will get the majority, my lord.
Please read this letter dated 2012.
Yes. But this is communication by the one of the corporator, my lord, to the deputy commissioner, third respondent.
Please read it.
ಪ್ಲೀಸ್ ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಕೆಳಗೆ ನಮೂದಿಸಿರುವ ಕರ್ನಾಟಕ ಸಭಾ ಪರಿಷತ್ ಸದಸ್ಯರು ವಿಜಯಪುರ ನಗರದ ಮತಕ್ಷೇತ್ರದ ವ್ಯಾಪ್ತಿಯ ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿ ಕೊಟ್ಟು ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿ ದುರುದ್ದೇಶದಿಂದ ತಮ್ಮ ಹೆಸರನ್ನು ನೋಂದಾಯಿಸಿಕೊಳ್ಳಲು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಫರ್ದರ್ ಸದ್ರಿ ಅವರು ಚುನಾವಣೆ ಗುರುತಿನ ಚೀಟಿಯನ್ನು ಪರಿಶೀಲಿಸಿ ಸೂಕ್ತ ವಿಚಾರಣೆಗೆ ಒಳಪಡಿಸಿ ಸದ್ರಿ ಅವರು ಯಾವ ಮತಕ್ಷೇತ್ರದ ವ್ಯಾಪ್ತಿಯಲ್ಲಿ ಆಗಿರುತ್ತಾರೆ ಮತ್ತು ಬರುವ ವಿಜಯಪುರ ಮಹಾನಗರ ಪಾಲಿಕೆಯ ಮೇಯರ್ ಹಾಗೂ ಉಪಮೇಯರ್ ಚುನಾವಣೆ ವಿಜಯಪುರ ನಗರ ಮತಕ್ಷೇತ್ರ ಮತದಾರ ಆಗುವ ಹುನ್ನಾರ ಮಾಡಿದ್ದು ಕಂಡು ಬರುತ್ತದೆ. ಈ ಕಾರಣ ಚುನಾವಣಾ ಮತದಾರ ಪಟ್ಟಿಯಲ್ಲಿ ಸೇರಿಸಬಾರದು. ಇಟ್ಸ್ ಎ ರಿಕ್ವೆಸ್ಟ್ ಲೆಟರ್ ಫಾರ್ವರ್ಡೆಡ್.
So he is saying that the names of these 4 members have to be deleted, not added.
That is some it's an error, my lord. It's a grammatical error. In fact, my lord, these 4 names have not been added yet, my lord.
Mr. ನಗರದ ಮತಕ್ಷೇತ್ರದ ವ್ಯಾಪ್ತಿಯ ಮತದಾರರ ಪಟ್ಟಿಯಲ್ಲಿ ಕೊಟ್ಟಿ ದಾಖಲೆಗಳನ್ನು ಸಲ್ಲಿಸಿ ದುರುದ್ದೇಶದಿಂದ ತಮ್ಮ ಹೆಸರನ್ನು ನೋಂದಾಯಿಸಿಕೊಳ್ಳಲು ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ.
ಅರ್ಜಿಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. But they have not
therefore they want their names to be included. Then where is the question?
Not been included, my lord, as per the annexure D I have provided. May kindly peruse annexure D for a moment, my lord, page number 35. It's an voter list provided by the 5th respondent Tashildar.
Yes.
In that, these 4 names have not been added yet.
It is not added. So therefore, there is no question of adding or deleting.
Yes. Till then, till Thursday, my lord, let the
No, no,
Tahsildar
let,
not.
let it come day after tomorrow.
Please.
Please,
Oblige.
day after tomorrow.
Please, grateful.
35 ಏನಾಯ್ತು 34.
I approve for the petition. Lord, I am challenging the annexure G impugned order passed by the trial court. I am the plaintiff before the Lord trial court. The suit for specific performance has been filed based on agreement of sale, my lord. The defendant number 1 is the owner, and defendant number 2 to 8 are the subsequent purchaser. They also rely on one agreement of sale. Their contention is that the defendant number 1 has executed another agreement of sale in their favor.
Defendant
Lord,
number 1,
while-
defendant number 1 is the owner.
Defendant number 1 is the owner, my lord. Defendant number 2 to defendant 2 to 8 are, my lord. They are also purchaser of the same property.
Under an agreement.
There is another agreement of sale.
Defendant number 9 ಯಾರು?
Same, Lord. Defendant number 8, 9 all are, my lord,
Yes.
purchasers.
Yes.
Lord, when I plaintiff, my lord, try to mark the document, the court says that it is insufficient stamp duty. My lord directed me to pay deficit stamp duty and that IA is allowed. And my lord, I have paid the stamp duty. When defendant, my lord, has trying to mark his agreement of sale, I raised the objection. The trial court kindly see, my lord, page number 50, say that, my lord, with the ಖರೀದಿ ಪತ್ರಗಳು ತಕರಾರಿಗೆ ಒಳಪಡಿಸಿ ಎಕ್ಸಿಬಿಟ್ ಎಂದು ಗುರುತಿಸಲಾಯಿತು. It is, my lord, with objection it is marked. Therefore, I filed an IA number 8, my lord, for the deficit stamp duty. That came to be rejected by the trial court, holding that since it is already marked the document, the trial court has no jurisdiction to
issue emergent notice. In addition, learned counsel for the petitioner is directed to serve the learned counsel for the respondents for the trial court. Full stop. ಏನು ಪೊಸಿಷನ್ ಕೊಟ್ಟಿದ್ಯಾ?
ಅಲ್ಲ, ವಿತೌಟ್ ಪೊಸೆಷನ್ ಇದೆ, ಬಟ್ ಇಟ್ ಇಸ್ ಇನ್ ವ್ಯೂ ಆಫ್ ದಿ ಕರ್ನಾಟಕ ಅಮೆಂಡ್ಮೆಂಟ್ 2016. ಇಟ್ ಇಸ್ ಓನ್ಲಿ ಅಂಡರ್ 200 ಸ್ಟ್ಯಾಂಪ್ ಮಾಡಿದ್ದಾರೆ. ದೇ ಹ್ಯಾವ್ ಟು ಪೇ, ಮೈ ಲಾರ್ಡ್.
ಎಷ್ಟಿದೆ? ವಾಟ್ ಇಸ್ ದ ಕನ್ಸಿಡರೇಷನ್?
Consideration amount, my lord, I produced the agreement of sale. That is,
What is the consideration?
yes, my lord. It is 35,53,110.
What is the stamp duty payable?
Stamp duty, my lord, as per the
20,000.
yes,
Maximum is 20,000.
20,000 as per Karnataka amendment section article 5.
Issue emergent notice. Yes.
Sought for stay, my lord. Now
What?
stay of the further proceedings.
Why?
No, if, my lord, already it is posted for
Regarding court fee, stamp duty.
defendant evidence is already closed, my lord, then.
Stay.
And otherwise, trial court is hurrying, my lord, disposing of the matter. That's what.
ಯಾವತ್ತಿದ್ರು ಸ್ಟಾಂಪ್ ಡ್ಯೂಟಿ ಕಲೆಕ್ಟ್ ಮಾಡ್ಬೋದಲ್ಲ?
If it is case
Let
is
the
closed, my
matter
lord,
go on. Yes, you suit.
suit of the year, my lord, is two of the 2020, my lord. That's why
2000?
that's.
Right, let the matter go on. Yes. Next.
Plus, some, my lord, date may be given, I request.
ಸರ್ವ್ ಮಾಡ್ಕೊಂಡು ಮೂವ್ ಮಾಡಿ. Yes, please.
Not, sir. This writ petition is by the plaintiff. The plaintiff, the petitioner herein filed suit for specific performance. Then, my lords, during the evidence, they sought to not mark the agreement of sale. Not annexure C1, page number 30. The other side has raised the objection. And subject to objection, my lords, was again posted. Then, my lords, court has passed an order at my lords, page number 40. The sale is sale agreement is impugned and office is directed to send the copy of the sale agreement to sub-register Basun Bagawadi, requesting to calculate penalty and stamp duty on the said document and intimate to the court. Then, my lords, They have produced the sale agreement at annexure D1, page number 41, my lords.
Hmm.
18 lakhs is the sale consideration amount, and 13 lakhs was paid, my lords, as earnest money.
Hmm.
And my lords, due to the, at page number 42 in the last para, my lords,
Hmm.
since there were some technical issue in issuing the documents, therefore the registration was postponed. On that count, my lords, the sale agreement was executed. Then, my lords, at annexure E, page number
Possession is
44,
given.
my lords,
Possession is given under the.
possession is given, my lords. But
What is-
10-time penalty has been imposed at the page number, in page number 45, impugned order, my lords.
Hmm. Hmm.
The 10-time penalty is not much compulsory. Even as per the section 37, the authorities have vested with the discretion to reduce it, my lords. The word used is may in the section 37 while calculating the stamp duty.
This is the judgment of the Supreme Court. ಯಾವ್ದದು?
Trustees of HC,
Times
that
ಅದು-
Ganganna ಒಂದು ಎರಡು judgment. There are 2 judgments, my lords.
There's one latest judgment of the Supreme Court. ಅದು ಎಲ್ಲಿದೆ? It cannot, 10 times is the maximum ಅಂತ ಏನೋ ಒಂದು judgment ಬಂದಿತ್ತಲ್ರಿ? ಎಲ್ಲಿ ಅದು?
2020 ಇದೆ.
ಹೌದು.
Para 23.
Hmm.
Para 25 minutes. '24 and 25. The collector, by imposing 10 times penalty in his order, has given a reason for imposition, as the party has not mentioned the actual nature of the document with the intention to escape the duty. When the collector found intention to escape the duty, it was the case of the imposition of penalty, but whether reason given by the collector is sufficient for imposition of
You're
extreme
willing
penalty
to
of
pay
10.
double the amount.
Yes.
You're willing to pay double the amount.
Yes.
For court. The plaintiff invoice number so and so on the file of so and so is before this court challenging an order dated so and so by which the court imposed, by which the court referred the document, referred an agreement of sale for collection of duty and penalty. Next para. The suit invoice number 119 of 2016 was filed for specific performance of an agreement of sale dated 7/3/2015. The suit was contested by the defendants, who denied the execution of the agreement of sale. The suit was set down for trial, and the plaintiff was examined as PW1, full stop. When he tried to mark the agreement of sale as an exhibit, the same was opposed by the defendants on the ground that sufficient stamp duty was not paid thereon. Full stop. The trial court produced the document and held that the possession of the suit property was delivered to the plaintiff under the agreement sale. And therefore, the plaintiff was bound to pay stamp duty as prescribed under Article 5E1 of the Karnataka Court Fees and Suits Valuation Act. However, the plaintiff had paid insufficient stamp duty thereon, and therefore impounded the document in exercise of its power under Section 33 of the Act, and referred the document to the sub-registrar for determination of duty and penalty. Full stop. Being agreed by the said order, the plaintiff is before this court. Next para. The learned counsel for the plaintiff contended that in view of the judgment of the apex court in the case of Gangappa and another versus Fakirappa in civil appeal 11/932 of 2018, it is not necessary that penalty at 10 times the duty has to be imposed. He submits that the plaintiff is entitled to go before the deputy commissioner and seek for refund of the penalty. Therefore, he contends that the apex court, taking into consideration the above fact, they taking into consideration the above provision made in law for refund, had held that collecting double the amount stamp duty as penalty would be sufficient complaints instead of relegating the parties before the deputy commissioner for refund of the penalty. Full stop. The learned AGA, on the other hand, contended that the law mandates that the plaintiff pay penalty at 10 times the duty, and after payment of such penalty, it is for the plaintiff to approach the deputy commissioner seeking for refund of the excess penalty, refund of the penalty paid. He submits that the deputy commissioner, in exercise of his discretion, would determine what is the amount liable to be refunded to the petitioner. Therefore, he contends that the plaintiff cannot avoid paying the duty and penalty as prescribed under law. Next para. I have considered the submissions of the learned counsel for the plaintiff and the learned AGA for the respondent number 4. Next para. When an insufficiently stamped document is produced before an authority or a court capable of receiving evidence, the court has no other option than to impound the document and direct collection of duty and penalty. Full stop. Once the duty and penalty is collected, the court collected, it is always open for the party to apply before the concerned deputy commissioner under section 38 of the Karnataka Stamp Act 1967 for refund of the penalty. Full stop. The section 38 provides that the deputy commissioner may collect penalty up to may impose penalty of a sum of ₹5 and refund the excess. Full stop. Therefore, though there is a procedure prescribed under the Act for payment and refund of the penalty, since it is submitted by the learned counsel for the petitioner that the petitioner would pay up twice the amount of stamp duty towards the deficit stamp duty as well as the penalty, interest of justice would be met by permitting the plaintiff to pay the deficit stamp duty as well as an equal amount of stamp duty as penalty, without driving the petitioner to go before the deputy commissioner seeking for a refund. Full stop. This would also take sufficient care of the interest of the revenue. In that way of the matter, this writ petition is disposed of on the following terms. Number 1, the writ petition is allowed in part. The impugned order passed by the trial court impounding the sale agreement dated so and so is upheld. However, the plaintiff is permitted to pay the deficit stamp duty on the sale agreement and also an amount equivalent to the stamp duty payable as penalty. Full stop. Upon payment of such deficit stamp duty and penalty, the trial court shall receive the document in evidence and proceed in accordance with law. Yes.
Not one more
The
submission.
plaintiff shall not be entitled to seek for any refund before the deputy commissioner.
They have calculated 5.65%, my lords. the amount stamp duty file imposing, it's incorrect because there is an 5% is the amount.
Whatever you want to.
That may be, otherwise they will know.
It is open for the petitioner to, pay the stamp duty as provided under law. As prescribed under law. 39, Mr. D.P. Ambekar.
The respond number of 5 to 7, madam.
Yes, madam.
Only prepare time for filing objection to petition, madam.
Don't want to argue.
Filing objection to petition.
Again, argument ಮಾಡ್ತೀರಾ, you want, what do you want? You want time?
ನನ್ಗೆ ಅವರು ನಮ್ದು ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 5 to.
ಇಲ್ಲಪ್ಪ, ನೀವು ರೆಡಿ ಇದ್ದೀರಾ?
ಇಲ್ಲ ರೆಡಿ, ಅಬ್ಜೆಕ್ಷನ್ ಆಗ್ತೀನಿ. Statement of objection.
And short date maybe within week or?
Learn counsel for the petitioner and the learn counsel for the respondent number 5 to 7.
5 to 7.
Bableshwar. Seeks time. List on. ಈ 2021 ಇಟ್ಕೊಂಡು ಇದೇನಾಗುತ್ತೆ? ಎಷ್ಟು ತುಂಬಾ ಕೇಸ್ಗಳು ಇದೆಯಾ ನಿಮ್ಮ ಹತ್ರ? ತುಂಬಾ ಬಿಸಿ.
ಲಾಸ್ಟ್ ಟೈಮ್ ವಕಾಲತ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಬೇಗ ಕೇಸ್ ಮುಗಿಸ್ಕೋಬೇಕಲ್ಲಪ್ಪ. ಲಿಸ್ಟ್ ಆಗಿದೆ ಕೇಸು, ಮುಗಿಸ್ಕೋಬೇಕಲ್ವಾ?
ಸ್ಟೇಟ್ಮೆಂಟ್ ಹಾಕಿದ್ರಲ್ಲ.
Taking adjournment is not a matter of right, mister. Matter ಲಿಸ್ಟ್ ಆಗಿದೆ, ಅಬ್ಜೆಕ್ಷನ್ಸ್ ರೆಡಿ ಮಾಡಿ ಹಾಕ್ಬೇಕಲ್ವಾ? ಯಾವಾಗ ವಕಾಲತ್ ಹಾಕಿರೋದು ನೀವು? 4 months ಆಗಿದೆ, ಇನ್ನೂ ಅಬ್ಜೆಕ್ಷನ್ ಹಾಕಿಲ್ಲ ನೀವು. ಜುಲೈ 8 ತಿಂಗಳಾಯ್ತು. 2 weeks. ಲಿಸ್ಟ್ ಆನ್ ಡೇಟ್ ಕೊಡಿ. Raghuram Kadambi.
Lord, may I make one submission for R1, R3 and R4, my Lord. Today I am advised to, my Lord, take, Lord, notice on behalf of, my Lord, as, my Lord, earlier counsel been, my Lord,
Mr. Sudarshan.
It's become a senior counsel, please.
Mr. Sudarshan undertakes to appear for the response 1 to 3. Office is directed to M. Sudarshan, alva?
M. Sudarshan. R1, R3 and R4, please.
R3?
R1, R3 and R4.
R1, R3 and R4. What about R2?
R2 is, my Lord, private party, Bharat Steel, and probably, my Lord.
R2 is chief engineer.
R1
R1 is Gulbarga Electricity.
R1, my Lord, I take. Wherever, my Lord, just come is shown, my Lord, I will file.
R2 is Discom, R3 is Discom.
Right, please.
Mr. M. Sudarshan undertakes to appear for the respondents 1 to 3. Office is directed to show his name in the cause list. List on date, please.
Much.
Harshavardhan.
Lord,
Your Lordship, appearing for the petitioner. Your
Lord,
Lordship, kindly have it next week.
Yaudu?
My Lord, 41 serial number. What had happened, my Lord, the respondent one, Srimati Dana, my Lord, passed away. I received, my Lord, information.
Respondent?
1. Srimati Dana, contesting respondent, my Lord, she passed away.
For the respondent number 1 submits that the respondent number 1 has expired. Learned counsel for the petitioner seeks time to take steps to bring the legal heirs. List after 2 weeks.
2 weeks immediately.
Your Lordship, there is a interim order, it may kindly be extended.
Satodar ಮೇಲೆ ಏನು interim order?
ಅಂದ್ರೆ ಲ್ಯಾಂಡ್ ಟ್ರಿಬ್ಯುನಲ್ ಆರ್ಡರ್ ಇದೆ ಸರ್.
Interim order granted earlier is extended till the next date of hearing. It is made clear that if no steps are taken by the next date, the petition shall stand dismissed as having abated. Please.
Obliged.
Mahantesh Patil.
Lord, I appear for respondent 1. State Commission, I mean, State Information Commission.
Yes. How could you do this, Mr.?
Yes.
You are defeating the purpose of RTA Act.
Yes, Lord, the proceedings dated 21/12/2021. Lord,
The very purpose itself you are defeating.
Yes, my lord, I understood.
ಮತ್ತೆ?
My lord, whatever, my lord, learned, my lord, whatever.
Then I don't know whether you people are doing the cataloging of the documents or not. Cataloging ಮಾಡ್ತಿದ್ದೀರಾ?
ಮಾಡ್ತಾ ಇದ್ದಾರೆ sir. Recently, my lord, it has been settled in, my lord, office has been opened in Gulbarga also. They are slowly, my lord, sorting out all these matters.
Slowly ಏನು 2005 Act.
2005 matter.
ಹಾ.
It is old
19
matter.
ವರ್ಷ ಆಯ್ತು. ಇನ್ನ slowly ಅಂದ್ರೆ ಎಷ್ಟು?
ಅಲ್ಲ, present trend I am, lord, bring.
Sir, how can it be so slow?
Yes.
19 ವರ್ಷ ಆದ್ರೂ ಇನ್ನ ಕ್ಯಾಟಲಾಗಿಂಗ್ ಮಾಡಿಲ್ವಾ?
ಅಲ್ಲ, ಅದು ಮಾಡ್ತಾರೆ ಸ್ವಾಮಿ. ಅಲ್ಲಿ ಬೆಂಗಳೂರಲ್ಲಿ ಇದೆ. It is there.
No. ಯಾವ ಕೊಡ್ತೀರಾ information?
Lord,
When will you comply the information to be furnished?
yes. Lord, it may be on 15th I will provide, my lord, whatever that it is. Annexure E is a, my lord, order.
ಸರಿ, ಅವ್ರು FIR ಇಟ್ಟು ಅವ್ರಿಗೇನು ಉಪಯೋಗ ಏನು? They want the information.
They want information.
ಅವ್ರಿಗೆ FIR ಕಟ್ಕೊಂಡು ಏನಾಗ್ಬೇಕು ಅವ್ರಿಗೆ?
ಹೌದು. Lord, I will take them, Lord, instruction through them, Lord, concerned officer. And I will explain the situation also, my lord. And accordingly, on 15th, I will submit back, my lord, whatever the details, my lord.
Learned counsel for the respondent number 1 seeks time.
In fact, in the morning, the Gaurish Kashampur sought time.
ಇಲ್ಲ ಕರೆಕ್ಟ್ ಅವ್ರ ಇನ್ಫಾರ್ಮೇಶನ್ ಕೊಡ್ತೀವಿ ಅಂತ ಹೇಳ್ತಿದ್ದಾರೆ. ಕೊಟ್ರೆ we can as well dispose of the petition ಅಲ್ವಾ? It seeks time to furnish the information as sought for by the petitioner. This on 15th.
15. I will try my best, please.
Emma Kulkarni.
My lord, I appear for the respondent.
Objections ಹಾಕಿದ್ದೀರಾ?
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಯಾವಾಗ ಹಾಕ್ತೀರಾ?
2 weeks time may be granted, my lord, I'll file it.
Learned counsel for the respondent number 2 and 3 seeks time to file statement of objections. Hence as a last chance list on 21st.
Oblige, my lord.
Mahesh Patil.
Lord, I'm Lord, retired Lord, English lecturer Lord, in an aided institution. Here, Lord, earlier Lord, I was the institution Lord,
Admitted to salary grant.
admitted to salary grant Lord, I was appointed Lord in 1990, and Lord, on 15 Lord, on my Lord, institution was Lord, admitted to grant in aid on 28/8/91.
When was your appointment admitted to salary grant?
Yes, 15/6/1993.
ಓದಿ ಅದೇನ್ ಹೇಳುತ್ತೆ?
That is at page 12.
ಓದಿ ಏನ್ ಹೇಳುತ್ತೆ?
Please. Page 12. ಬೋಧಕ ಸಿಬ್ಬಂದಿ ನೇಮಕಾತಿ ಅನುಮೋದನೆ. ಶ್ರೀ ಜಗದಂಬ ವಿದ್ಯಾವರ್ಧಕ ಸಂಘ ಶಾಂಬಾ ಇಂಡಿ ತಾಲೂಕು ವಿಜಯಪುರ ಜಿಲ್ಲೆ ಇವರು ಆಶ್ರಯದಲ್ಲಿರುವ ಶ್ರೀ ಜಗದಂಬ ಪದವಿ ಪೂರ್ವ ಕಾಲೇಜ್ ಇಟ್ನಳ್ಳಿ ತಾಂಡ ಸಿಂದಗಿ ವಿಜಯಪುರ ಜಿಲ್ಲೆ ಈ ಶಾಲೆಗೆ ಆಡಳಿತ ಮಂಡಳಿಯವರು ಬೋಧಕ ಹುದ್ದೆಗಳಿಗೆ ನೇಮಕಾತಿ ಮಾಡಿಕೊಂಡಿದ್ದವನ್ನು ಉಲ್ಲೇಖಿತ ಪತ್ರದಲ್ಲಿ ಸರ್ಕಾರವು ಈ ಹುದ್ದೆಗಳಿಗೆ ಆರ್ಥಿಕ ಮಿತಿ ವ್ಯಯವನ್ನು ಸಡಿಲಿಸಿ ಹಾಗೂ ಇಳ್ಕೊಂಡ ಷರತ್ತುಗಳಿಗೆ ವಿಧಿಸಿ ಅನುಮೋದಿಸಿದೆ. My name, my lord, appears at serial number 2. My lord, ನೇಮಕಾತಿ ದಿನಾಂಕ 6/8/90. And my lord, here, my lord, the ಷರತ್ತುಗಳಲ್ಲಿ, my lord, ಈ ನೇಮಕಾತಿಗಳು ಭವಿಷ್ಯಧ್ವನಿ ಅಂದರೆ ಸರ್ಕಾರಿ ಆದೇಶ ಸಂಖ್ಯೆ 15/6/93 ಜಾರಿಯಾಗುವುದು. ಯಾವುದೇ ಕಾರಣಕ್ಕೂ ಸದರಿ ಹಿಂದಿನ ಬಾಕಿ my lord, the condition number 3, ಸದರಿ ಅವರು ಹಿಂದಿನ ಸೇವೆಯನ್ನು ರಜೆ ಮತ್ತು ನಿವೃತ್ತ ವೇತನ ಸೌಲಭ್ಯಗಳಿಗೆ ಮಾತ್ರ ಪರಿಗಣಿಸತಕ್ಕದ್ದು. And my lord, the previous, my lord, the service, my lord, which they should reckon, my lord, from the initial date, my lord, of my appointment, my lord, that is, my lord, 1990. And my lord, thereafter, my lord, we.
So from 1993, your appointment was admitted to salary grant.
Yes. Now, my lord, what I'm seeking, my lord, that my, my lord, period has to be reckoned, my lord, from 1990, the date of my initial appointment. And that was, my lord, one of the, my lord, they have mentioned in, my lord, in the condition, my lord, of my
For the
order.
purpose of pension, how can when you were appointed as a teacher in the school, it was not pensionable.
Aided, my lord, aided, it's an aided institution, my lord.
93 ನಿಮ್ದು salary grant admit ಆಯ್ತು.
Yes,
So you're entitled for pension by treating your service from 1993.
yes.
Where's the question of treating your service from 1991?
19, because, my lord, very much, my lord, they had mentioned, my lord, in my order, which is at, my lord, condition number 3, that the page 12.
Page 12.
Yes, my lord.
ಏನಂತ ಇದೆ?
ಸದರಿ ಅವರ ಹಿಂದಿನ ಸೇವೆಯನ್ನು ರಜೆ ಮತ್ತು ನಿವೃತ್ತ ವೇತನ ಸೌಲಭ್ಯಗಳಿಗೆ ಮಾತ್ರ ಪರಿಗಣಿಸತಕ್ಕದ್ದು. My lord, by virtue of this, my lord, and my lord, I was eligible, and thereafter, my lord, we filed an, my lord, writ petition, my lord, before this honorable court. My lord, it is at annexure E, page 13. My lord, I am one of the, my lord, the petitioner, my lord, in the writ petition. And my lord, this honorable court, my lord, was pleased to pass this order, my lord, at page 30, in page 30.
Yes.
My lord, relying on the, my lord, the earlier decision, my lord, of this honorable court in connected matters. And my lord, my case was also disposed of. And my lord, it was held, my lord, that my period has to be reckoned, my lord, from my earlier initial date of appointment. This was, my lord, thereafter, my lord, the government, my lord, they, my lord, issued these rules, which are at page 32. On 12/2/2024.
Yes.
My lord, here they, my lord, making it applicable, my lord, retrospectively. And my lord, here, my lord, my lord, this, my lord, prevented, my lord, by, my lord, considering my initial period of appointment for the sake of pension. And now, my lord, the state, my lord, they have filed, my lord, writ appeal, my lord, before this honorable court, my lord, at principal bench, which is, my lord, pending even till today. And, my lord, in the meanwhile, my lord, I had retired from service now. Now, my lord, in an identical matter, and now the pension payment order, my lord, is at page 41.
So this order passed by the learned single judge is challenged in writ appeal.
Yes, my lord, yes.
Yeah.
And, my lord, the now.
Page number 13 is challenged in writ appeal.
Yes, ma'am. This is.
But ಅದೇನ್ ಆಗಿಲ್ವಾ? Appeal is still pending.
Pending.
No, but when the appointment was, initial appointment was not subject to pension, how can the past service be considered?
Initial appointment was subject to pension, my lord. And even I have been, my lord.
An order passed. That is the order passed. But tell us, when your initial appointment was not pensionable, suppose if you had retired.
Yes, ma'am.
Suppose if you had retired without your appointment being subject to grant in aid, you are not entitled for pension.
Yes, ma'am, very much. And here in my case, my lord, my initial, my lord, appointment was subject to, my lord, pension. And I've been, my lord, now pension is granted to me. I have produced the pension payment order also.
That is from what date?
That is, my lord, from 15/6/1993, page 41.
15/6/1993, you are entitled to.
Yes, my lord.
15/6/93, you are definitely entitled to.
Yes.
But question is from 1991, when you were appointed.
Yes.
When your appointment was approved by the state government, whether you are entitled for pension from that day onwards.
Yes, my lord, from that day onwards, my lord, that is what, my lord, was, my lord, the subject matter, my lord, in the petition.
Writ appeal decide ಆಗ್ಬೇಕಲ್ಲ.
Yes, my lord. Now, my lord, in identical matter, my lord, one such, my lord, which I have produced, my lord, at page 44, my lord. In identical matter, my lord, one of my, my lord, such colleague, my lord, he had, my lord, approached this honorable court. And, my lord, this honorable court, my lord, had disposed of, my lord, the writ petition, my lord, page 44.
In view of the judgment passed in this petition, similar.
Similar, my lord, and now, at the most, my lord, what I can seek, my lord, that in on, my lord, my lord, similar, my lord, identical, my lord, the, if order, my lord, is extended to me also, my lord.
Correct, but writ appeal decide agli.
Even ಇದರಲ್ಲಿ ಅದೇ ತರ ಹೇಳಿದ್ದಾರೆ. The same, my lord, it may be disposed of in these terms kindly. Page 48.
Barcode. The petitioner has sought for a writ in the nature of mandamus to consider his representation dated 21/11/2022 and count his service from 6/8/1990 to 15/6/1993 for the purpose of pensionary benefits. Full stop. Next para. The petitioner contends that he was appointed as an English lecturer,
Yes,
an English lecturer on
my lord, 6/8/1990.
1990 at Sri Jagadamba Vidya Vardhaka Sangha, Tamba, Pindi Taluk, Vijaypura district. Full stop. His appointment was
My lord, one,
approved.
I am working, my lord, at Nutan Vidyalaya.
ಅದೇ ಜಗದಾಂಬ ಅಂತಿದೆ.
ಮೊದಲು ಅಲ್ಲಿಂದ
ಕಟ್ ಅಂಡ್ ಪೇಸ್ಟ್ ಮಿಸ್ಟೇಕ್ ಅದು.
ಮುಂದೆ ಅಲ್ಲಿ ಬಂದಿತ್ತು.
Full stop ಆಯ್ತು. Full stop. His appointment was approved on 28/8/1991. Full stop. Later, his appointment was subject to grant in aid, was admitted to aid, and his appointment was admitted to salary grant on 15/6/1993. Full stop. The respondent number 3 granted the benefit of the pay scale as prevalent in the respondent number 2. Full stop. The petitioner contends that in the order granting the pay scale dated 6/7/1993, it was mentioned that the petitioner is entitled to count his past service for the purpose of leave and pensionary benefits. Full stop. The petitioner contends that he retired from service on
is it PPO?
31/10/2020.
Yes.
Full stop. His pensionary benefits was settled by treating his service from 15/6/1993. The petitioner therefore submitted a representation ಅರುಣ್ ಕುಮಾರ್, ನೀವು ಈ WP ನಲ್ಲಿ ಇಲ್ವಾ ನೀವು?
WP ಅಲ್ಲಿ ಇದ್ದೀನಿ.
00927 ಇಲ್ವಾ?
ಇದ್ದೀನಿ 77 serial number page 26 serial number 77.
ಏನ್ ಮೇಡಮ್ ಆಯ್ತು? ಬಂದೆ 1990. Full stop. Therefore, the petitioner and others approach this court in WP number 200927-201013/2014 for a direction to the respondents to count the past service rendered by them for the purpose of pay scale, seniority, increments, pension, etc. Full stop. The said writ petition was disposed of in terms of the order dated 23/1/2014 on the same lines as in WP number 19431/2005 and connected writ petitions, which was affirmed by the division bench of this court in Writ Appeal 848 of 2008 and by the Honorable Supreme Court in SLP Civil 22176-22186 of 2010. Full stop. The petitioner contends that the respondent 1 and 2 have now promulgated the Karnataka private educational institutions, private aided educational institutions, staff bracket, pay, pension, and other benefits rules 2014, in terms of which, the past service is not counted for the purpose of determining the pensionary benefits. Full stop. The petitioner therefore submitted a representation dated 22/11/2022, requesting the respondents to consider the past service, that is from 6/8/1990, for the purpose of determining the pensionary benefits payable and accordingly revise the pension fixed. Full stop. The petitioner submits that in similar circumstances, a coordinate bench of this court in WP number 23263 of 2021. Petitioner submits that the order passed in WP number 200927-201013 of 2014 is challenged in Writ Appeal 2647 of 2015, and the same is pending consideration. He submits that a coordinate bench of this court in WP number 23263 of 2021 had permitted the petitioner to make appropriate representation to the respondents 1 and 2 to count the unaided period for service benefit as well as for pensionary benefits after disposal of Writ Appeal 2647/2015 and connected appeals. He therefore contends that the petitioner be extended the same benefit and the petitioner be permitted to file an appropriate representation after disposal of Writ Appeal 2647 of 2015. Next para. The learned HCGP on the other hand contended that the petitioner's appointment was admitted to salary grant with effect from 15/6/1993, and therefore the petitioner cannot compel the respondents to count past service when his appointment was not admitted to salary grant. He submits that the liability to pay pension is only from the date the appointment of the petitioner was admitted to salary grant. Thus, she contends that the petitioner is not entitled to any reliefs in this writ petition. Next paragraph. Since a coordinate bench of this court in WP number so and so has already held that had already directed ಅದೆಲ್ಲಿ ಇದು 19431 of 2005 ಇಲ್ಲಿದೆ ಇದು ಕಾಪಿ ಇದೆಯಾ WP number 19431 of 2005 since a coordinate bench of this court following the judgment in WP number 19431 of 2005 had disposed of WP number 200927-201013/2014 filed by the petitioner and others, comma, which is presently challenged by the state government in Writ Appeal 2647 of 2015, comma, the only relief that can be extended to the petitioner is to permit the petitioner to file appropriate representation requesting the respondents 1 and 2 to consider counting the unaided period of service, unaided period for service benefits as well as pensionary benefits after disposal of Writ Appeal 2647 of 2015 and connected appeals. Full stop. Consequently, the following order is passed. The writ petition is allowed in part. The petitioner is permitted to submit a representation to the respondents 1 and 2 to requesting them to count the unaided period of service for determination of the terminal benefits as well as the pensionary benefits. Full stop. This shall be only after disposal of Writ Appeal 2647/2015 and connected appeals. If a representation is made, comma, the respondents 1 and 2 shall consider the same in accordance with law and in the light of the judgment that may be passed in Writ Appeal 2647 of 2015.
So one small correction. In this judgment, my lord, writ appeal, my lord, number has come as 2647, but the number is 2476, which I have submitted,
2476.
2476 of 2015.
Nagaraj Patil.
Appear for the petitioner in this matter. Petitioner is owner of land survey number 49.
Yes, Mr. Is there any acquisition initiated?
My lord, I am for the respondent number 2 and 3. The acquisition initiated by the respondent number 4 and 6 are the necessary party, my lord. That come under State Highway, National Highway Division. They have made a National Highway Authority of India is the no way concerned. Memo is filed, my lord. Our authority letter is issued, the memo is filed on 2724.
No, the state highway is sought to be upgraded to a national highway.
Yes, my lord. This project will under maintaining the state highway along with National Highway Division.
Whether the state highway is upgraded to a national highway.
National Highway, yes, my lord.
Then you are the one who is answering.
Our is the National Highway Authority of India is the separate body, my lord.
That is okay, but who is developing the highway? You are developing?
State government is developing
Not
under
you.
National Highway Division. The respondent number 6 is the necessary party. 6 is the maintaining the road.
Already, according to the petitioner, his land is being used up for development of a national highway.
Yes, ma'am.
Who is developing the national highway? Are you developing?
Respondent number 6.
Yaro.
National Highway Division and the separate body.
Who are you now? Neevarige.
Now 2 and 3 party ಮಾಡಿದ್ದಾರೆ National Highway Authority of India. ಅದಕ್ಕೆ we are appeared and filed a memo, my lord. Our authority has issued letter to their respondent number 6. 2724 ಕಿನ memo along with document of.
ಏನಂತ?
ಅವರ jurisdiction ಬರೋದಿಲ್ಲ, ಅವರು National Highway Division jurisdiction ಬರುತ್ತೆ, ನೀವೇ ಡಿಪೆಂಡ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ.
So ಯಾರು ಆನ್ಸರ್ ಮಾಡಿ? Who has to answer?
ಅವ್ರು 6 ಮಾಡ್ಬೇಕ್ರಿ.
6 year. Who appears for respondent number 6?
State government ಬರುತ್ತೆ.
State government ಹೆಂಗ್ರಿ ಮಾಡ್ತಾರೆ? ಗೌರ್ಮೆಂಟ್ ನೀವ್ ಹೇಳ್ಬೇಕಾ?
Information I have, sir. Here is the case, my lords, wherein it was earlier notified for acquisition, my lords. Subsequently, they issue an endorsement, my lords, that in the earlier road only we are carrying out the work, my lords. At annexure G, page number 36, my lords. But, my lords, in the property of the petitioner, my lords, already they have formed bus stop and everything, my lords. And my representation was also not considered. When I submitted a representation for passing of the award, my lords, and this endorsement has been issued by the authorities.
Who is the answering respondent? ಯಾರು ಹೇಳ್ಬೇಕು? Who is the answering respondent? Earlier ಏನೋ acquire ಆಗಿತ್ತು.
Permission of the road.
Now they are saying ಮುಂಚೆ ಎಷ್ಟಿತ್ತೋ ಅದನ್ನೇ ಅಪ್ಗ್ರೇಡ್ ಮಾಡ್ತಿದೀವಿ, ಡೆವಲಪ್ ಮಾಡ್ತಿದೀವಿ, ಇಂಪ್ರೂವ್ಮೆಂಟ್ ಮಾಡ್ತಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. They say that that you have acquired a larger portion. ಅದು compensation code ಅಂತ ಕೇಳ್ತಿದ್ರು.
It was notified, my lords. It was notified, JMC was conducted, the 3 guntas of land of petitioner was will be used, my lords. And thereafter, my lords, they issue endorsement subsequently before passing an award. Since award was not passed for a considerable time, I gave a representation to pass an award to the extent of 3 guntas, my lords, which was utilized by them. They issue endorsement at Annexure D stating that the work is been carried out in the earlier portion only, my lords, and the land of the petitioner is not utilized.
So no award is passed.
No award is passed till date, my lords, but they have formed the bus stop and everything in the land of the petitioner, my lords. I have enclosed the photographs also to that effect.
Yes.
Take the information from respondent number 6, my lord.
Lord, HCGP seeks time to secure information from the respondent number 6. List on date code.
Please, oblige.
C. Jagadish.
I'm appear for respondent number 1 and 2, 3. 1, 2, 3, my lord.
Ready? Are you ready?
Swami, illa Swami, 2 weeks time kodi Swami, objection file ಮಾಡ್ತೀವಿ Swami.
Regarding the caste certificate.
Yes, sir.
For election purpose, I don't
But I had challenged, my lord, the order of the caste verification committee and the appellate, my lord, order, commissioner's order.
You're challenging the order passed by the DCVC.
Yes, my lord.
Yes, sir.
And
Learned counsel for the respondent number 1 to 3
1,
seeks
2,
time.
3.
List after 2 weeks as a last chance. Seeks time to
Oblige,
file
my lord.
objections.
my lord, some date.
Oblige.
List on 22/1 as a last chance.
Yes.
ಹಿಂಗಂತ ಹೇಳಿ ಇನ್ನೊಂದು 50 ಕೇಸ್ ಲಿಸ್ಟ್ ಮಾಡಿಸ್ತಾ ಇದ್ ನಾವು.
Please.
I would have got another 50 cases listed. ಎಲ್ಲಾರು ಟೈಮ್ ಕೇಳಂಗಿದ್ರೆ.
I am ready in this matter, my lord.
Correct, but one or the other party is not ready.
Yes.
I thought out of 56, even if I dispose of 20 matters. Because from tomorrow onwards, I'll list 100 matters. ಇನ್ನೇನ್ ಮಾಡೋದು? ಯಾರು ಬರ್ದೇ ಇದ್ರಿ.
Oblige, my lord.
Amir Hamza. KM Gate. Mr. KM Gate.
The memo is submitted before this honorable court, madam. To transfer the case to principal bench.
For what? You want the
Service-
matter to go before the principal bench?
No, sir. Similar cases, lots of connected. Connected matters, my lord, 5 matters.
Case is covered.
Yes, sir.
Yes, what is the case?
The regularization of services, my lord. Group D employees.
Regularization of service.
Yeah. My lord, please annexure O, my lord.
Annexure O, my lord, serial number, page number 96.
Yes, Mr. What about the Supreme Court judgment? In the light of the judgment of the Supreme Court, why the same benefit should not be extended to the petitioners? Hmm? Yeah, who is answering respondent? Karnataka Pashu Vaidikiya Pashu, who appears for that?
Is out of station.
Huh?
My senior is out of station.
To transfer.
So you already passed an order regularizing the services of some daily wagers. Why don't you extend the same to the petitioners also? Have you read the file?
Petition copy is not there.
Petition copy na ಕೊಟ್ಟಿಲ್ವಾ?
ಕೊಟ್ಟಿದ್ದೀವಿ sir.
File ಒಳಗೆ ಏನಿದೆ ಮತ್ತೆ? What do you have in the file then?
Memo.
Have a copy of the petition.
ಇಲ್ಲ ಕೊಟ್ಟಿದ್ದೀವಿ sir, signature ಮಾಡ್ಬೋದು sir, KM ಮಾಡಿ.
He says copy is not furnished one. ತೋರ್ಸಿ ಅವ್ರಿಗೆ. You make a photocopy at your cost.
Kindly give me on next short date.
He will go to the Xerox shop. ಒಂದು Xerox copy ಮಾಡಿಸ್ಕೊಂಡು ದುಡ್ಡು ನೀನ್ ಕೊಡ್ಬೇಕು. ಬರ್ಕೊಡ್ರಿ. Learn counsel for the respondent number 2 to 4 seeks time to file objections. List on ಯಾವತ್ತು ಬೇಕು? Don't say copy ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಇನ್ನೊಂದ್ಸತಿ. ಹೋಗಿ ಕಾಪಿ ಇಸ್ಕೊಳ್ಳಿ.
1 week or
List on 15th. ಅರ್ಥ ಆಯ್ತಾ? ಏನ್ ಹೇಳಿ?
ಇದು petition copy.
ಇಸ್ಕೋಬೇಕು. ಮುಂದಿನ ವಾರ ಬಂದು ಅದೇ ಹೇಳಿದ್ರೆ ಐ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಇಟ್. Yes. Madan Kumar Mitra. Ganesh Kalaburagi.
Case, I'm appearing for respondent number 4 and 5, your lordship. So information incomplete is there, so I have filed statement of objections also. That is 2 weeks time may be granted.
And what is the relief sought for?
Land was granted in my.
Land was granted?
By assistant commissioner.
To you?
Yes, my mother and father.
To your father and brother?
So that their case is that those lands were subject to the proceeding before the land tribunal. And the.
ಅಂದ್ರೆ excess land ಅಂತ ಆಗಿತ್ತಾ?
We were the tenant and it was granted to us. That.
Yes, Mr. What are the facts?
My lord, surplus land order ಆಗಿತ್ತು my lord. Surplus land my lord.
Surplus land order ಆಗಿತ್ತಾ?
Order ಆಗಿತ್ತು. The order passed by land tribunal, that is annexary D and F is illegal and
both against to High Court order, my lord.
Hmm.
Order dated 10/9/1999.
Hmm.
My lord, ಅವರು ಈ annexary D and F illegal ಇದಾವೆ, my lord.
What is your name?
ಮದನ್ ಕುಮಾರ್ ಮಿತ್ರ.
ಮದನ್ ಕುಮಾರ್. ಕತೆ ಹೆಂಗ್ ಹೇಳೋದು? ಕತೆ ಕೇಳಿದಿರಾ? How do you narrate facts? Facts ನ ಹೆಂಗ್ narrate ಮಾಡೋದಪ್ಪ?
Yes, ma'am, I will read out more facts.
You have not read the facts?
Yes, ma'am.
You are aware of the facts?
Yes, ma'am.
Tell it in simple language, what are the facts?
My lord, the fact is, the petitioner has approached before the Honorable High Court of Bangalore, order dated 10/9/99. The Honorable High Court order passed by that is common order dated
So the court said, directed the land tribunal to reconsider the application
within 6 months.
within 6 months. ಆಮೇಲೆ ಏನಾಯ್ತು?
ಇಲ್ಲಿವರೆಗೆ ಮಾಡಿಲ್ಲ ಕನ್ಸಿಡರ್ಸ್, my lord. The matter is pending before land tribunal Raichur.
Yes.
And my lord, my petitioner filed a representation letter before land tribunal Raichur, that is annexure C, to remedy the matter as per order passed by Honorable High Court. ಅದನ್ನ ಕನ್ಸಿಡರ್ ಮಾಡಲಾರ್ದೆ, my lord, 10 the land tribunal passed on dated 10/1/2023 on favor of respondent 4 and 5, which is pending before matter Raichur land tribunal.
Mr. Respond 4 and 5 ಹೆಂಗ್ ಬಂತು ಜಮೀನು?
My lord, ಅದು annexure B. Special Assistant Commissioner order dated 22/10/1981, my lord.
Typed copy or
So after section 63 proceedings,
Yes,
the
ma'am.
land was granted to these people.
Yes.
That is order is.
ಒಂದು simple ಆಗಿ ಹೇಳಕ್ಕಾಗಲ್ವಾ? If you can't say it in English, you can say it in Kannada.
Yes. Sorry.
Excess land
Excess land ಆಗಿದೆ.
ಡಿಕ್ಲೇರ್ ಆಗಿದ್ದನ್ನ ಸೆಟ್ ಅಸೈಡ್ ಆಗಿದೆ, ರಿಮ್ಯಾಂಡ್ ಆಗಿದೆ, ಎಕ್ಸೆಸ್
ಆಗಿದೆ.
ಲ್ಯಾಂಡ್ ಅವ್ರು ಗ್ರಾಂಟ್ ಮಾಡಿದ್ದಾರೆ.
Yes.
ಅಷ್ಟು ಹೇಳಕ್ಕಾಗಲ್ವಾ?
This annexure B order, that has not been challenged.
No, that's okay if the order,
Is caution.
No, that order is earlier order of the Honorable High Court, which is passed is of 28/10/1981.
grant ಮಾಡುವಾಗ he was not heard before granting. If the main order itself goes, the subsequent order also goes.
Under 77 proceeding, inquiry has been.
77 because 63. 77 is, the land is granted.
Yes.
That land
That-
was actually resumed to the government for, it was an excess land.
And
That order is now set aside. Matter is remanded back to the tribunal to consider the declaration. So where's the question of,
and this order has to be challenged, 22/7.
why should it be challenged? It is gone.
No, the 82 order not gone here. That,
Correct, Ray? ಹೋಯ್ತಿದೆ, order ಹೋಯ್ತಿದೆ. It has no legs to stand. It is no longer excess land. It is no longer excess land. If it is no longer excess land, until the tribunal decides the question, how can the tribunal pass an order to make out the khata in your name?
and this is Assistant Commissioner order.
ಅದೇ ಹೆಂಗ್ ಮಾಡ್ತೀರ
The Assistant Commissioner order is on basis of the order dated 22/7/1982.
ಆಯ್ತು. 42 and 43 ಹೆಂಗ್ ಮಾಡ್ತಾರೆ ಕೋರ್ಟ್ನವರು?
Yes.
How can the tribunal direct the Tahsildar
Not
to
the
transfer
tribunal.
the revenue records even before considering the declaration filed by the petitioner's mother or whatever. ಪಾಣಿ ಹೆಂಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ ಅಂತ ಕೇಳ್ತಿರೋದು.
They have order, the assistant commissioner's order, which they have not now challenged.
They may not challenge. They may not challenge. Till the declaration filed with them is accepted or rejected, this order passed by the assistant commissioner is kept in suspended animation. It is suspended. Until the land tribunal says that it is an excess land, this order will not come back to life. Only when the proceedings is dismissed, this order will come back to life. Ashtena?
But little bit, if your lordship gives some time, your lordship, then I will.
Time for
do
what?
this. So I will get some more information regarding the proceedings of the tribunal, whether these persons were the respondent 4 and 5 were the parties to or not, or.
This is not the issue. Tribunal ಮುಂದೆ decide ಆಗಿದ್ಯಾ?
That information I don't, he is in better position, your lordship.
Tribunal ಮುಂದೆ decide ಆಗಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಿದ್ದಾರೆ.
Lord, still it is pending
I'll
before
give you
land.
1 week time.
Yes, yes. Finally.
Counsel for the respondent number 4 and 5
Yes.
seeks time.
My lord,
Secure
please
instructions
grant
whether
return, please.
the proceedings before the land tribunal regarding the declaration filed by the mother of the petitioner,
No, my lord, ancestor property.
regarding the
Father of the.
grandmother of the petitioner is disposed or not. Yes. List on
Next week, any day.
15th, 15th.
Much.
Yes. Mahesh Patil. VK Naik.
Yes.
Mahesh Naik.
Yeah.
VK Naik. ಏನ್ ಸಚಿನ್ ಮಹಾಜನ್ ನೆನ್ನೆ ಕರೆದಿದ್ದು ಇವತ್ತು ಬರ್ತಾ ಇದ್ದೀರಾ? No, actually I want. No, that is right, but I called you yesterday, you come today.
My lord, here, my lord, the petitioner, my lord, she is a, my lord, retired teacher, my lord. Now, my lord, due to the wrong information, my lord, sent by the, my lord, the management, my lord, to the accountant general, my lord, reduced, my lord, pension has been fixed. My lord, now, my lord, I was admitted to grant in aid, my lord, at page number 27, my lord. Page number 27. My lord, there, ಅದರಲ್ಲಿ second last column ಅಲ್ಲಿ 16/7/1987 ಇಲಾಖೆಯಿಂದ ನೇಮಕಾತಿ ಅನುದಾನ ಅನುಮೋದನೆ ದಿನಾಂಕ. This is an admitted fact.
ಹುದ್ದೆಗೆ ಸೇರಿದ ದಿನಾಂಕ.
ಹುದ್ದೆಗೆ ಸೇರಿದ ದಿನಾಂಕ 16/7. ಆಮೇಲೆ ಇಲಾಖೆ ವತಿಯಿಂದ ನೇಮಕಾತಿ ಅನುದಾನ ಅನುಮೋದನೆ ದಿನಾಂಕ 16/7/87. This is, my lord, when I, my lord, admitted to grant in aid. And, my lord, thereafter, my lord, I retired from service, my lord, in the year 2022. Even while sending proposal, my lord, to the accountant general, the management, my lord, rightly, my lord, at page 37. Page 37. They sent a proposal, my lord, by 16/7/87. Rightly they had sent. But in one of such, my lord, paper, in the very same proposal, my lord, at page 55, page 55. ಇದರಲ್ಲಿ 3 ಕಾಲಮ್ ಇದೆ. TBS ಸರ್ಟಿಫಿಕೇಟ್ ಅಂತ. ಅದರಲ್ಲಿ ರೈಟ್ಲಿ, my lord, in the first, my lord, ಕಾಲಮ್ ಅದರಲ್ಲಿ ಹೇಳ್ತಾರೆ, ಶ್ರೀ ಸೋ ಅಂಡ್ ಸೋ ಅವಧಿ ಡಿಸ್ಟ್ರಿಕ್ಟ್ ಸೋ ಅಂಡ್ ಸೋ ಅನುದಾನಕ್ಕೆ ಒಳಪಟ್ಟರೆ ಸದರಿ ಸಿಬ್ಬಂದಿಯು ದಿನಾಂಕ 16/7/87 34/22 ಪಡೆದಿರುವ ವೇತನ ಮತ್ತು ಭತ್ಯೆಗಳು ಇಲಾಖೆಯಿಂದ ವೇತನ ಅನುದಾನಕ್ಕೆ ಒಳಪಟ್ಟಿದೆ ಎಂದು ಪ್ರಮಾಣೀಕರಿಸಿದೆ. ರೈಟ್ಲಿ, my lord, they say so. Now, my lord, at serial number 2, my lord, in the very same, my lord, they, my lord, wrongly mention, my lord, ಅನುದಾನಕ್ಕೆ ಒಳಪಟ್ಟ ಸದರಿ ಸಿಬ್ಬಂದಿಯು ದಿನಾಂಕ 21/10/95 31/8/2021 ಪಡೆದಿರುವ ವೇತನ ಹಾಗೂ ಭತ್ಯೆಗಳ ಇಲಾಖೆಯಿಂದ ವೇತನ ಅನುದಾನಕ್ಕೆ ಒಳಪಟ್ಟಿದೆ ಎಂದು ಪ್ರಮಾಣೀಕರಿಸಿದೆ. This is contrary to their very own, my lord, that in serial number 1. And serial number 3, my lord, ಶ್ರೀಮತಿ ಗೀತಾ ಸೋ ಅಂಡ್ ಸೋ ಪ್ರಿನ್ಸಿಪಲ್ VP ನಾಯಕ್ PU ಕಾಲೇಜ್ ಅಂತ ಹೇಳ್ತಾರೆ. I am not working at that VP ನಾಯಕ್ PU college at all. Some, my lord, some copy paste has happened. And my lord, based on this, my lord, now these two columns, my lord, the proposal was sent to Accountant General. Accountant General, my lord, they, my lord, asked, my lord, these, my lord, respondents to, my lord, to clarify the correct, my lord, date, my lord, as to when I was admitted to grant in aid. My lord, instead of sending the, my lord, the correct information, once again, my lord, now, my lord, they sent, my lord, the wrong information with, not only with regard to, my lord, my date of entry into service, even with regard to my last paid drawn. Last paid drawn also, my lord, they, my lord, reflected some other, my lord, pay instead of my pay, which, my lord, I have produced by way of documents. That page 58 may kindly be seen. Page 58. Now, my lord, they say 22 to 1991 to 34, 22 is aided institution anta ಹೇಳ್ತಾರೆ. My lord, this is again, once again, a wrong information because, my lord, 1970 it was admitted to grant in aid, which I have produced a document. And page 59, my lord, my emoluments, instead of sending, my lord,
Madam, who is responsible for this?
my lord, the
I will-
BEO, my lord, even they should have, my lord, verified and, my lord, sent it.
Keep that BO present in the court.
Please, please.
He is responsible, Allah. He is the one responsible.
Yes, my lord.
Or could I learned CGP is directed to keep the respondent number 3 present before the court on the next date of hearing to explain how a wrong date of entry into service of the wrong date of entry into service was mentioned for the purpose of determining the pension payable to the petitioner. This list on yavat. When can you keep him present?
20th, Your Lordship.
List on 20th.
Sir, pass for matter after lunch. Court officer.
Sir, ಅದು ಸ್ವಲ್ಪ serial number 2 ಮತ್ತೆ 3 ಸ್ವಲ್ಪ ಇತ್ತು. Official ಹಾ. ಬರೆದಿದ್ದಾರೆ.
ಎರಡು ಎಂಡ್ ಆಫ್ ಲಿಸ್ಟ್ ಅದು. ಇದು ಯಾವ ಡೇಟ್ ತಗೋಬೇಕ್ರಿ ಹರ್ಷ ಅವ್ರೆ? ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಟ್ಟದ್ದು ರೆಪ್ರೆಸೆಂಟೇಶನ್ ಕೊಟ್ಟ ಡೇಟ್ ಎಂದು ಇದೇ ಕಂಟಿನ್ಯೂ ಅನು ಇದೇ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಇದೇ ರೆಪ್ರೆಸೆಂಟೇಶನ್
ಅಲ್ಲ ಸರ್ ಅಲ್ಲ ಅದು ಬೇರೆ ಕಾಪಿ ಕೊಡ್ತೀನಿ.
ನಮಗ ಅದೇನು ಇದೇ ಇಲ್ಲಿ ನಮ್ಗೆ
ಅಲ್ಲಲ್ಲ.
ಅಷ್ಟೊಂದಾಗೈತ ಅದಕ್ಕೆ
ಇಲ್ಲ ಅದು ಸ್ವಲ್ಪ ಚೇಂಜ್ ಮಾಡಿನ ತಪ್ಪ ಹಾಕ್ಯಾರ. ಇದು
ಇದು ನೀವು ಕೊಟ್ಟದ್ದು
7/12/2020.
ಇದು ನೀವು ಕೊಟ್ರಿ.
ಹೌದು
ಎಲ್ಲ ಇವ್ರ ಮೆಂಬರ್ಸ್ ಕೊಟ್ಟದ್ದು ಇದು
ಸರ್ ಅದು
ಹ್ಮ್.
ಇಲ್ಲ ಸರ್ ಇದು ಇದು ಅದ ಕಾಪಿ ಅದ ಕಾಪಿ ಅದ ನೋಟಿಸ್ ಅದ ಕಾರಣ ಕೇಳ ನೋಟಿಸ್ ಒಬ್ಬ ನೋಟಿಸ್ ಅದ ಅದು ಆಯ್ತಾ. ಇದು ನಾವು ಕೊಟ್ಟಿದ್ದೆ ರೆಪ್ರೆಸೆಂಟೇಶನ್
ನಿಮಗ್ ಕೊಟ್ರಿ ಅಂದ್ರ ನಾ ಹೆಂಗ್ರಿ ಮೇಡಮ್ ನಮಗನು ಕೇಳ್ತಾರಲ್ಲ ಮತ್ತೆ ಇಲ್ಲ ಮೋಷನ್ ಆಫ್ ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಐತೆ ನಮಗ ಹಿಂಗ ಮುಖಾನ ನೋಡ್ತಾರಲ್ಲ ಸಾಹೇಬ್ರು. ನಮ್ಮ ಹತ್ರ ಬೇರೆ ಬುಕ್ ಐತ ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ ಪಂಚಾಯತ್. ಯಾಕಂದ್ರೆ ಇಟ್ಕೊಂಡು ಇಲ್ಲ ಅಂದ್ರೆ ನಮ್ಮ ಮುಖ ನೋಡ್ತಾರ ಅವ್ರು.
ಏನ್ರಿ ಸಾವ್ಕಾರ ಏನ್ ನಡ್ಸಿರಿ ನೀವು?
ಏನ್ ನಡ್ಸಂಬ್ರಿ ಜಾದವ್ರ ನಿಮ್ದೇ ನಡೆಯೋದು ನಾವ್ ಸುಮ್ನೆ
ಅಲ್ಲಿ ಧ್ವನಿ ಫುಲ್ ಜೋರ್ ಕೇಳಾಗ್ತದ್ರಿ ಧ್ವನಿ.
ರನ್ನಿಂಗ್ ಏನಿಲ್ಲ.
ಊಟ ಐತ್ರಿ? ಸರಿ ಸರ್ ಮತ್ ಸಾಹೇಬ್ರು ಬರ್ತಾರ್ರಿ ಈಗ.
ಓಕೆ ಓಕೆ
ಎಸ್ ಸರ್.
ತಕೊಳ್ರಿ ಇದರ್ಗ ಆಗ ಇಲ್ಲ ಐತ್ ನೋಡ್ರಿ.
ಚೇಂಜ್ ಆಗಿ ಬೇರೆಯವರು ಈಗ ನೀವ ಇವರು ವೀರನಗೌಡ ಮಾಡಿ ಪಾಟೀಲ್ ಅಂತ.
ಸರ್ ಪಂಚಾಯತ್ ರಾಜ್ ರೂಲ್ಸ್ ಅಲ್ಲ.
ಇಲ್ಲ ನೀವು ಬಂದು ಅವ್ರಿಗೆ ಭೇಟಿ ಆಗಿ ನಂಬರ್
ಪಾಟೀಲ್ ರೇ
ಸರ್ ಏನದು ಮನಿಲ್ಲ ಹೈಕೋರ್ಟಿಗೆ ಬರ್ಬೇಕು ಅದೆಲ್ಲ ಗೊತ್ತಿಲ್ಲ.
Any two of the members signing the notice to the assistant commissioner.
3 subsection 1. ನಮಸ್ತೆ.
ಇದೊಂದು ಟೈಪ್ ಮಾಡಿ ಈ ರೂಲ್ಸ್ ಅಂತ ಗೊತ್ತಾಗಬೇಕು. ಪಾಟೀಲ್ ರೇ ಪಾಟೀಲ್ ಇದು ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ ಪಂಚಾಯತ್ ರಾಜ್ ಮೋಷನ್ ಆಫ್ ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಅಗೇನ್ಸ್ಟ್ ಅಧ್ಯಕ್ಷ ಉಪಾಧ್ಯಕ್ಷ ರೂಲ್ಸ್. ಕರ್ನಾಟಕ ಗ್ರಾಮ ಸ್ವರಾಜ್ಯ ಅಂಡ್ ಪಂಚಾಯತ್ ರಾಜ್ ಅದು ಅದ್ರಾಗೆ ಬರ್ತಾ ರೂಲ್ಸ್ ಹಾಕಿರ್ತಾರ. ರೂಲ್ಸ್ ಎಲ್ಲ ಇದ್ರಾಗ
ಇನ್ನೊಂದು ವಿತ್ ಅಲಿಗೇಷನ್ ಇರ್ಬೇಕಂತದ ಅಂದ್ರೆ ಏನು ಅಲಿಗೇಷನ್ ಜಸ್ಟ್
ಅದನ್ನ ಬಿಟ್ರ ಅವ್ರು ಅಲಿಗೇಷನ್ ಬಗ್ಗೆ ಮಾತಾಡಿಲ್ಲ ಸಾವು. ಈಗಿದ್ರ ನಿಮ್ಗ ತಹಸೀಲ್ದಾರ್ ತಗೊಂಡ್ರ ಅನ್ನೋದಕ್ಕೆ
Humble submission. No, service matter and labor matters are pending from 12, 13, 14 minutes. It may be taken 2 days.
2 days alone. There's only 5 days left in a week.
Yes. 12,
One day Service matter.
Service
matter.
labor, service labor.
Service and labor 1 day.
12, 13, 14 in the pending though.
KLR, land reforms, CPC, tax, other things 1 day. DMC, general miscellaneous matter 1 day. In ಮಿಕ್ಕಿದ ಏನಿದೆ ಅದು ಒಂದೊಂದು day.
1 day.
Service matter ball pending.
అవుನು.
Service labor,
ಎಲ್ಲದಕ್ಕೂ ಒಂದೊಂದು day.
12, 13, 14 my lords.
ರೆಡಿಯಾಗಿ ಬನ್ರಿ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಸ್ಕೊಂಡು ಹೋಗಿ.
Obliged.
ಸರಿ. ಹೇಮಾ ಕುಲಕರ್ಣಿ.
Tender matters. Earlier, Honorable Court granted the interim order, my lord.
Now, what is this? What is the matter? What is the issue?
Now, technical bid has rejected, my lord. They have preferred appeal. First appeal is dismissed. Now they have preferred second appeal before Principal Secretary. It is pending, my lord. Last date of hearing, Honorable Court directed to dispose before next date of hearing. Today is the last time, yes.
But is it listed before the commissioner?
Yes, my lord.
ಏನಾಗಿದೆ?
ಇಲ್ಲ ಅಪ್ ಟು 7th ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ. ಇವತ್ತು ನಾಳೆ ಗೊತ್ತಾಗುತ್ತೆ my lord. It has an order passed.
Then we'll take it up day after tomorrow.
Yes, my lord.
Yes, Sachin. 52.1. Second appeal is pending ಅಂತ ಏನ್ ಹೇಳ್ತಿದ್ರಲ್ಲ.
The second appeal is pending. There is no scope for second appeal, my lord.
I don't know.
Inadvertently, my lord, they have filed. But in the similarly situated matter, my lord, previous bench has taken a view. This very matter, my lord, of
Anyway,
transportation.
now that right or wrong, you filed an appeal. Or you must challenge the order passed in the first appeal before this court withdrawing.
In fact, my lord, if your lordship kindly peruses the interim order granted by this honorable court, that fact is taken into consideration. In fact, there was a direction, my lord, to the appellate authority to dispose of the appeal.
Correct. No, you filed some second appeal. I don't know how you could file.
That was, my lord, a wrong thing to do.
That was a wrong thing that you did. Then you must have challenged the order passed in the, by the first
It
appeal.
is still pending, my lord. That is also challenged, my lord, before.
ಈ writ petition challenge ಮಾಡಿದಿರಿ? Whether the appeal, order passed in the, by the appellate authority is challenged here.
Lord, the prayer in the writ petition is I am only
the
sought for
appeal-
mandamus, my lord, to consider my.
So what do you want to do?
Day after tomorrow, your lordship may have, my lord, I will file an application for amendment. In the meanwhile, my lord, there is an order. In a similarly situated, my lord, matter, I will share the copy and my lord. Please.
What is order sheet code? In view of the order dated 17/12/2024 and the statement made by the learned AGA that the appeal before the appellate authority is listed today.
Yes.
Comma, list day after tomorrow.
Please. Obliged. But I'm sorry, my lord, I could not appear yesterday, my lord.
Is nenne matter, Sachin, idu?
My lord.
Was this matter listed yesterday?
It was not this matter, it was a different matter.
Yashas Dikshit.
Additional building either.
Milord.
Number 53.
Fifth floor, fifth. 528. 430.
My lord, 53 and another password are similar, my lord. One matter, SS is password, my lord.
ಯಾವ್ದು serial number?
Serial number, my lord. 32.
40?
32.
ಎಲ್ಲ same.
Yes, ma'am. He has to appeal before under section of KTPP, my lord. Without approaching appellant authority, yes.
Please, Your Lordship, this is a similar matter, Your Lordship. Wherein one ground that I have in this matter is, there was a similar tender that was called, Your Lordships, which is at Annexure G, Your Lordships. There my similar tender with the same conditions was called for. There my tender, in technical bid, uh, my bid was accepted, Your Lordships. But when the same condition is there, in this tender, my bid is rejected, Your Lordships.
So therefore you go before the authority.
Yes, Your Lordships, a mandamus may be issued directing them to furnish all the documents, relevant documents that I have sought at Annexure.
Now, are you sure that the financial bid is accepted?
Financial bid is open, Your Lordships. Financial bid is closed as well, Your Lordships. Issuance of work order itself is remaining, Your Lordships.
Issuance of work order
Itself is remaining, Your Lordships.
is remaining.
Yes, Your Lordships. Work order has not been issued.
Who is the successful bidder?
Now, I have to ascertain because, my lord, at the time of writ petition, only technical bid has been completed.
Oh,
Yes.
correct, but then
Yes, I will,
furnish the documents list tomorrow.
day after tomorrow, my lord, I will say.
The learned counsel for the petitioner submits that the petitioner is handicapped in as much as the petitioner is not in a position, petitioner of learned counsel for the petitioner submits that the petitioner is not able to file an appeal challenging the rejection of the technical bid, since the particulars of acceptance of the financial bid of the successful bidder is not furnished. The learned AGA submits that the particulars will be furnished to the petitioner by day after tomorrow. Yes, list day after tomorrow.
Your Lordship, similar order may be passed in serial number 32.
Same order in serial number 32.
Yes,
Obliged, Your Lordships.
Madam Anita Reddy,
Needful done, Your Lordship.
what are the facts?
Your
What
Lordship.
is challenged, madam?
Yes, Your Lordship, I'm challenging the order that's passed by the family court. That is page number 19 regarding the interim maintenance as well as litigation expenses. And there, in that, they mention the notional income. Income of the husband is 18,000, and he is working in the mobile shop, and he is getting only 4,000. His income is only 4,000.
You do one thing, you ask him to resign his job.
Please.
You ask him to resign his job, let him come to the High Court, we'll employ him at 6,000 rupees.
You know, that is the right now. In 2019, he lost the job because
Madam,
of that.
4,000 rupees per month
Yes,
is less than the minimum wages.
yes. Yes.
100 rupees per day.
Yes, Your Lordship. I agree, but that mobile shop, how much that small mobile shop is there?
Yes.
So for that reason only, they are paying the only 5,000 rupees per month.
Let him not work there. Ask him to come to the High Court.
That is not a remedy. But this
Well,
below court order that the.
Can anybody believe that an able-bodied man is working in a shop for
Mobile
only
shop.
4,000 rupees? Can anybody believe this?
Because of that reason, right now he left the job, and she also left the petitioner, and she working in Pune, and she's getting 18,000. She's working in mall, Your Lordship, and she's getting 18,000. We want to prove that aspect. But meanwhile, this 4,000 rupees interim maintenance along with the litigation expenses ordered by the below court. So litigation expenses we are ready to pay. So at least 2,000 per month till disposal of the.
No. 4,000 rupees is the bare minimum for any person to survive.
Yes, Your Lordship. I agree, but the income is not there. And she left without any reason. She is a relative.
Expedition ಏನು?
Next petition is regarding the, your lordship, kindly writ of prohibition to direct the principal judge to order the expeditiously, because she filed the divorce petition before the family court on the basis of cruelty by the husband.
Prohibition in writ of prohibition ಅಂದ್ರೆ?
Prohibition,
What is writ of prohibition?
to direct the judicial authority. So that is a writ of prohibition
ನೋಡಿ
to direct, please.
ಓಪನ್ ಮಾಡಿ ಗೂಗಲ್ ಕೊಡಿ
Please.
ಕೊಡ್ರಿ ಇಲ್ಲಿ
I will write.
ಕಾನ್ಸ್ಟಿಟ್ಯೂಷನ್ ಬುಕ್ ಕೊಡ್ರಿ. ವಾಟ್ ಇಸ್ writ of prohibition?
Writ of prohibition is a judicial order.
What?
Writ of prohibition is a judicial order that prevent a lower court from the interfering with a higher court's determination of a case. It is issued by the higher court at its discretion, and it is considered as a drastic remedy. And writ of prohibition can be issued when a lower court is acting as without or excessive.
ಏನಂಗಂದ್ರೆ ಅರ್ಥ?
This writ of prohibition is one order which can be passed by the judicial authority.
ಇನ್ನೊಂದ್ಸತಿ ಓದಿ, ನಿಧಾನಕ್ಕೆ ಓದಿ, ಅರ್ಥ ಮಾಡಿ.
Yes. That is the a writ of prohibition is a judicial order that prevents a lower court from the interfering with a higher court's determination of a case. Then it is issued by the higher court at its discretion, and it is considered as a drastic remedy. And after that, a writ of prohibition can be issued when a lower court is acting without or any excess of jurisdiction.
ಇದರಲ್ಲಿ ಏನಂತ ಕೇಳಿದಿರಾ?
Because here that order passed by the lower court, and we are seeking by way of writ of prohibition to direct the lower court to pass the order expeditiously. That is my understanding.
Prohibition ಅಂತ ಬರೋದಿಲ್ಲ.
So mandamus, how can one higher court can direct the lower court?
Mandamus ಬರೋದಿಲ್ಲ.
Yes.
ಅದಕ್ಕೆ ಸ್ವಲ್ಪ ಓದಿ ಅಂತ
Please,
ಹೇಳೋದು.
correct. I will make a research and I will correct the prayer. ನಾನು ಓದ್ಕೊಂಡು ಹೇಳ್ತೀನಿ.
Then first petition dismiss ಮಾಡ್ಬೋದಾ?
Please, your lordship, till this, ನಾವು ಕೊಡಕ್ ರೆಡಿ ಇದೀವಿ, but he is till unemployed. 2000 ಮಾಡಿ we will proceed the evidence. Afterwards we will prove the.
4,000 ರೂಪಾಯಿಕ್ಕಿಂತ ಕಡಿಮೆ ಯಾರು ಮೇಂಟೆನೆನ್ಸ್?
ಇಲ್ಲ, ಅವ್ರು intentionally ಬಿಟ್ಟು ಹೋಗಿದ್ದಾರೆ. So we are ready to accept. But she is also not ready to rejoin. So only money is not a remedy that is there.
Who is she related to you?
She is my maternal uncle daughter, that ಮಾಮನ್ ಮಗಳೇ ಆಕೆ. So who is, please.
ಮಾಮನ್ ಮಗಳನ್ನೇ ನೀವು ಈ ತರ ನೋಡ್ಕೊಂಡ್ರೆ ಬೇರೆಯವ್ರನ್ನ
ಇಲ್ಲ ನೋಡ್ಕೊಂಡು, because she don't want to take care of her mother-in-law, ಮತ್ತೆ ದುಡ್ಡಿನಗೋಸ್ಕರ ಏನೋ ಜಗಳ ಆಗಿದೆ. So that is the only reason.
ಅಲ್ಲಿ ಇಶ್ಯೂ ನೋಟಿಸ್ ಅಷ್ಟೇ. ಇಶ್ಯೂ ನೋಟಿಸ್, ನೋ ಸ್ಟೇ. ಎರಡರಲ್ಲೂ
At least 2000 ಮಾಡಿ ಸ್ಟೇ ಮಾಡಿದ್ರೆ we will pay. That is the better option.
ನೋ ಸ್ಟೇ. Yes.
Please.
ವಿಳಂಬ. ರವಿಚಂದ್ರ ಜಾಧವ್.
Milord, I am appearing behalf of the petitioner in this case, Milord. So firstly, I beg to the apology, Milord. So the notification issued by the government authority on 9/10/2024 on the basis of the order which as you are enclosed in annexure A herein, Milord. Milord, I am audible, Milord.
You can reduce your volume. You are more than audible.
Milord.
Please reduce the volume. Never
Yes,
reduce.
Milord. Yes, Milord.
Don't scream.
Yes, yes, Milord. Now, audible, Milord.
ಹೇಳಿ.
So therefore, my lord, wherein also they mentioned that the 30 days, the application started 10/10/2024 to 9/11/2024, wherein
I asked you, where is
Yes,
the recruitment notification? Where is the
Sir,
recruitment notification? Why don't you understand?
yes, my lord. Annexure A is a requirement notification. On that basis only, respective district is called the notification, my lord. Annexure A.
So where is the recruitment notification?
My lord, we are not enclosed with this petition, my lord. I have to that.
You enclose it, we'll consider it after you enclose it. Barcode. Learned counsel for the petitioner is directed to furnish a copy of the recruitment notification. List after the same is done. Yes.
Much obliged, my lord.
Hmm. Last matter, huh? Arun Chaudapurkar?
Yes, sir.
Yes.
On behalf of Chodapur.
Ready, na?
Sir,
Are you ready?
Sir, I already have filed their death certificate, my lordship, in this case. So they have to, other side have to take the steps.
Who has, respondent number 2 has expired.
I already filed the death certificates also and some.
So who is respondent number 2?
Nanjun Swami, ma'am.
That I can read.
Ah.
But who is he?
Yeah,
Is the Mata the headman?
He is the,
Is the Mata headman?
who is the Mata head now?
Some alternate they must have arranged, I hope. I will next date of hearing, I can file.
Yes, what do you want to do?
so
Nanjun
last-
Swami ತೀರೋಗಿದ್ದಾರಂತೆ.
ತೀರೋಗಿದ್ದಾರೆ ಮೇಲಾಡ್. ಆದ್ರೆ ಅದಕ್ಕೆ ನಾನು ಮೆಮೋಗೆ ಕೌಂಟರ್ ಕೊಟ್ಟಿದ್ದೇನೆ ಮೇಡಮ್.
ಏನಂತ?
Counter is already resigned for the post of presidency, which is confirmed by the trial court in OS 138 of 95, which is confirmed in the RA 94/2005 and in RSA 7134/11.
ಆಯ್ತು, whether this petition survives, no, Nanjun Swami is dead and gone.
Yes.
So whether this petition survives. ಇವಾಗ
Let
ನಂಜುನ್
me-
ಸ್ವಾಮಿ ತೀರೋದ್ಮೇಲೆ
ಹಾ.
ಈ ಪಿಟಿಷನ್ ಸರ್ವೈವ್ ಆಗುತ್ತಾ?
ಸರ್ವೆ ಆಗುತ್ತೆ, ಎಕ್ಸ್ಪರ್ಟಿ ಆರ್ಡರ್ ಮಾಡ್ಬೇಕಲ್ಲ ಮೈಲಾಡ್.
ಅವ್ರು ತೀರೋದ್ರಲ್ಲ ಸರ್.
ಅವ್ರು ತೀರೋದ್ರು.
ಹಾ.
ಈಗ ಅದರ್ಸ್ ಆರ್ ಇಂಟರ್ಫಿಯರಿಂಗ್ ಇಲ್ಲಿಗಲಿ.
Others are interfering, you take steps against others in the manner known to law. But what is challenged in this petition?
I am challenging the members list issued by the Register of Societies.
What have you challenged?
Members list issued by the respondent number 1, my lord. So annexure
P2 and P3.
P2, P3, my lord.
ಏನ್ ಹೇಳ್ತದು?
P2, P3. One second.
ನಿಮ್ಮ ಯಾವ ರೀತಿ ಬೇಕೋ ಅದೇ ರೀತಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ. ನಿಮ್ಮ ಯು ಕ್ಯಾನ್ ಆರ್ಗ್ಯೂ ದ ವೇ ಯು ವಾಂಟ್.
ಈಗ ನೋಡಿ my lord. So is the respondent number 2 is already resigned. This is one Sivayogi Swami Memorial Education Society Kodla, which is registered under Societies Registration Act. As per the annexure A, so he is the president of the society and I am the general secretary of the society. As per annexure A, page number 1819, my lord. So on 19/6/95, the respondent number 2 is resigned for the post of presidency. After that, somebody is interfering. So therefore, we have filed the civil suit before the civil court
in OS 138 of 95. That is also decreed that he is null and void. The plaintiff 1 and 2 are declared as a president and general secretary of the society. In place of Nanjun Swami, one Santvir Swami has been elected. For them, he is elected as a president. I am continuing as a general secretary. That is. And against this order, the respondent number 2 has preferred an appeal before senior division, RA 94/2005, Annexure A3, my lord. That is also dismissed.
Yes.
And he preferred second appeal, RSA 7134/11, Annexure A. That is also dismissed. And again, he is misrepresenting to the respondent number 1 as a president of the society. For them, after the knowledge of the OS 138 of 95, the respondent number 1 has been cancelled his members list on 13/10/2008. On the basis of that, the respondent number 2 has been filed a writ petition before this honorable court. The honorable court is in WP number 40558/2008. In para 7, stated that rights can be decided only by the civil court. The registrar order is not a final. So therefore, you have to challenge your membership before competent court. But they did not challenge, they did not obtain injunction stay.
Yes.
As per the direction. Even though the respondent number 1 is also given endorsement to the respondent number 2 and 13/7/2010 as per Annexure B4, my lord. But so, even though they did not obtain any injunction stay from competent civil court,
Yes.
he lost his rights. Without that, so without that, I made representation to the respondent number 1 as per Annexure D 12/2/19. The second appeal is dismissed. So therefore, not to consider the representation of the respondent number 2.
Yes.
So after that, the present legal heir, Mr. Gnana Prakash Swami, has made representation to the secretary on 27/8/19. Annexure F, my lord. Annexure F. We are having a civil court order. He is not a party to the suit. He is not a member of the society. Even though he is misrepresenting to the secretary, as we are having a civil court order and high court direction. So therefore, not to consider the representation of the petitioner. So on the basis of that, secretary has been given a letter on 3/9/2019 as per Annexure F1.
Yes.
S1. ಶಿವಯೋಗಿ ಸ್ವಾಮಿ ಸ್ಮಾರಕ ವಿದ್ಯಾವರ್ಧಕ ಸಂಘ ಕೋಡ್ಲ ಕಲಬುರಗಿ ಸಂಘದ ವಿರುದ್ಧ ದೂರರಾದ ಶಿವಲಿಂಗ ಸ್ವಾಮಿ ಇವರು ಸತತವಾಗಿ ದೂರು ನೀಡುತ್ತಿದ್ದು, ಸದರಿ ದೂರುಗಳು ಯಾವುದು ಸಾಬೀತಾಗಿರುವುದಿಲ್ಲ. ಆದರೂ ಪುನಃ ದೂರು ನೀಡುತ್ತಿರುವುದರಿಂದ ಇನ್ನು ಮುಂದೆ ಇಂಥ ದುರುದ್ದೇಶಪೂರಿತ ದೂರು ಮನವಿಗಳ ಪರಿಗಣಿಸಬಾರದು ಎಂದು ನಿರ್ದೇಶಿಸಲಾಗಿರುತ್ತೇನೆ. ಆಸ್ ಪರ್ ದ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಡೇಟೆಡ್ 27/8/19, ಮೈ ಲಾರ್ಡ್. ಅದ್ರ ಪ್ರಕಾರ ಕೊಟ್ಟಿದ್ದಾರೆ. ಕೊಟ್ಟ ಮೇಲೆ ನಾವು ಹೋಗಿ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಆರ್ಡರ್ ಇದನ್ನೆಲ್ಲ ತಗೊಂಡೋಗಿ ಸೆಕ್ರೆಟರಿ ಕೊಟ್ಟು, ಅದ್ರ ನಂತರ ಅವರು 1910ಗೆ ಅವರು ಮತ್ತೊಂದು DRCSಗೆ ಒಂದು ಲೆಟರ್ ಕೊಟ್ಟರು. ಏನಂತ? ಸೊ ಅಧ್ಯಕ್ಷರು ಶಿವಲಿಂಗ ಸ್ವಾಮಿ ಅವ್ರು ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ, ಅದ್ರ ಪ್ರಕಾರ ವಿಚಾರಣೆ ಮಾಡಿ ನೀವು ಕ್ರಮ ತಗೊಳ್ಳಿ, ವರದಿ ಕೊಡಿ ಅಂತ. ಆನ್ ದಿ ಬೇಸಿಸ್ ಆಫ್ ದಟ್ they have issued a notice, my lord.
Yes.
As per the direction of the secretary, he is not inquired anything. Without inquiring, they have given a members list to the respondent number 2 as per annexure H, my lord. Annexure H1. So in H1, so without any rights, there also the respondent number 2 putting a signature as a president of the society. And
ಸರಿ ಸರಿ, ಇವಾಗ ನಂಜುಂಡ ಸ್ವಾಮಿ ತೀರೋದ್ರಲ್ಲ,
ಈಗ ತೀರೋದ್ರು.
So
ಈಗ
therefore
ತೀರೋದ್ರು.
ಇವಾಗ ಏನ್ ಉಳಿಯುತ್ತೆ ಇದ್ರಲ್ಲಿ?
ಅವ್ರು ತೀರೋದ್ರು. ಅವ್ರು ತೀರೋದ್ಮೇಲೆ ಈಗ ಜಸ್ಟ್ you have to consider the representation of the petitioner. As
For what?
Huh?
For what?
We have filed the members list before the respondent number 1.
ಹಾ,
ಅಷ್ಟೇ.
yes. ಎಲ್ಲಿದೆ ನಿಮ್ ರೆಪ್ರೆಸೆಂಟೇಷನ್?
Annexure S1, my lord, please.
Annexure?
Annexure S1, my lord.
Yes, sir.
Yes. 118, 120.
ಏನಂತ ಕೇಳಿದಿರಾ?
As per the Societies Registration Act, every year we have to file a members list before the Register of Societies. One 18, my lord,
Yes.
page number.
ಮರಿಯಪ್ಪ ಪೂಜಾರಿ ಇದರ ಇವರು?
ಇದ್ದಾರೆ.
ಸೋಮು. ನಿಮ್ದು. ಎಸ್ ಮಿಸ್ಟರ್, ನಿಮ್ದೇನ್ ಇಲ್ವಲ್ಲ, ತೀರೋಗಿದಾರ ಇನ್ನೇನು?
I will submit, next data I will take a
Don't worry.
implementive.
Work good.
Sad time may be given,
The
madam.
learned counsel for the respondent number 2 submits that the respondent number 2 has expired. Full stop. The same is noted. Expire. In order sheet al mabudu. The learned, same is noted. The learned counsel for the petitioner is directed to make appropriate entries in the cost title indicating the death of respondent number 2. Since the respondent number 2 purportedly claimed to be the president of the petitioner, there is no need to bring the legal heirs of the deceased respondent number 2 with order sheet. Next para. The petitioner contends that the respondent number 2 was a president of the petitioner and he later resigned from the post on 19/6/1995. Full stop. On the same day,
One Santveer Swami.
Shri Shantavira Swami was elected as the president. And was elected as a president. While Mr. Shivlinga Swami was appointed as the general secretary. Full stop. It is alleged that the respondent number 2 and others were interfering with the affairs of the petitioner, and therefore a suit in OS number 138 of 1995 was filed for declaration that Shri Shantavira Swami was the president and Shivlinga Swami was the secretary, general secretary of the society as per the meeting of the general body dated 19/6/1995. Full stop. They also sought for perpetual injunction restraining the respondent number 2 herein and another from interfering with the affairs of the society, of the petitioner, sorry, full stop. The said suit after contest was decreed and it was declared that that Sri Shantavira Swami was the president of the petitioner and Sri Shivalinga Swami was the general secretary of the petitioner society. So, an appeal was preferred by the respondent number 2 in RA 94 of 2005, which was dismissed in terms of the order dated, in terms of judgment and decree dated 22/9/2010. Full stop. The respondent number 2 then challenged the judgment and decree before this court in RSA 7173 of 2011.
7134
7173 ಅಂತಿದೆಯಲ್ಲ
ಇಲ್ಲ ಅದು ಬೇರೆ 7134/11
for 2011, which was also dismissed. Full stop. 7134 of 2000, which was also dismissed on 29/5/2018. Full stop. The petitioner contends that the list of office bearers was not registered and approved by the respondent number 1 in view of the pendency of dispute before the civil court as stated above. Full stop. Thereafter, the respondent number 2 submitted a list of members of the managing committee to the respondent number 1 on later, the respondent number 2 submitted a representation to the respondent number 1 to cancel the registration of the list of committee members for the year 2008-9. Full stop. The said representation was later the petitioner submitted a representation to cancel the list of managing committee members submitted by the respondent number 2. Full stop. Accordingly, the respondent number 1, after noticing the decree passed in OS number 138 of 1995, cancelled the list of committee members submitted by the respondent number 2 in terms of the order dated 13/10/2008. The respondent number 2 then challenged the said order before this court in WP number 40558 of 2008, which was dismissed. And this court directed the respondent number 2 to challenge the alleged challenge the resignation, challenge the correctness of the resignation submitted by him, as well as the elections held to the managing committee of the petitioner in an appropriate suit. Full stop. Following this, the respondent number 2 then submitted a request before the respondent number 1 to return the list of managing committee submitted by the petitioner for the year 2010-11. Full stop. The said request was, the said representation of the respondent number 2 was returned to the petitioner by the respondent number 1 on 13/7/2010. Full stop. In the meanwhile, Shantavira Swami died, Our Tirodra,
ಅವ್ರು ತೀರೋದು.
Shantavira Swami died on 29/9/2010. And Sri Shivlinga Swami was elected as the president of the petitioner. Full stop. The petitioner then filed WP number 83132/2010. Seeking for a direction to consider the representations filed for grant in aid for the year 1995-96 and 96-97. The said writ petition was disposed of in terms of the order dated 7/1/2011. Full stop. The petitioner again filed WP number 81348 of 2012 for a direction to the respondents therein to consider the representations dated 1/3/2012, 21/9/2011, 14/10/2011, and 22/9/2011. The said writ petition was also allowed and a direction was issued to the respondents therein to consider the representation filed by the petitioner. Full stop. Following this, the petitioner submitted a representation dated 12/2/2019 requesting the respondent number 1 to reject the statement of accounts filed by the respondent number 2. What is this 203436 ಏನಿದು?
ಅದು ಸಹ ಒಂದು ರಿಟ್ ಪಿಟಿಷನ್. ವಿ ಹ್ಯಾವ್ ಚಾಲೆಂಜ್ ದ ಮೆಂಬರ್ಸ್ ಲಿಸ್ಟ್ ಮೈ ಲಾರ್ಡ್ 203436.
Full stop. When things stood thus, a stranger purportedly claiming to be the general secretary of the petitioner submitted a representation dated 27/8/2019 to the principal secretary of the Department of Corporation not to entertain the request of Sri Shivalinga Swami, who was claiming to be the president of the petitioner. So following this, the principal secretary in terms of the letter dated 3/9/2019 addressed to the respondent number 1 and others directed them not to entertain the representations of Sri Shivalinga Swami, who claimed to be the president of the petitioner. Full stop. The petitioner, the president of the petitioner, on coming to know of the said representation, submitted a request dated 16/9/2019 enclosing therewith various documents to establish his claim that he was the president of the petitioner association. Following this, the respondent, the principal secretary of the Department of Corporation, addressed a letter dated 19/10/2019 to the respondent number 1 to submit a report about the list of members of the petitioner association. Full stop. The petitioner contends that the respondent number 1 forwarded a copy of the list of members for the year 2020-23 that was filed by the respondent number 2, though he had no manner of right, title or interest to claim as the president of the petitioner. The petitioner therefore contends that the petitioner therefore submitted a representation dated 26/9/2020, requesting the respondent number 1 to forthwith cancel the list of managing committee members filed by the respondent number 2 for the term 2020-23. ಇದೇನು ಇನ್ನೊಂದು ಹಾಕಿದ್ರೆ 203436 ಏನಿದು 203436 ಏನಕ್ಕೆ ಫೈಲ್ ಮಾಡಿದ್ರಿ?
203436, we are challenging the members list, my lord, 2023.
The petitioner then challenged the list of committee members filed by the respondent number 2. Before this court in WP number 203436/2019. ಅದೇನಾಯ್ತದು?
ಅದು you have to approach the proper forum ಅಂತ ಹೇಳಿ direction ಕೊಟ್ಟ.
The said
Liberty has been given.
Said writ petition was disposed of, reserving liberty to the petitioner to approach the competent court. Full stop. In the meanwhile, the petitioner submitted a representation before the In the meanwhile, the respondent number 2 purportedly submitted another list of committee members which comprised of himself and others for the period 2020-21 to 22-23. Which was registered, which was acknowledged by the respondent number 1. Full stop. The petitioner therefore submitted a representation dated dated
Page 118.
3/6/2024. Bringing to the notice of the respondent number 1 about the earlier proceedings and the ineligibility of the respondent number 2 to claim as the president of the petitioner and to register the list of committee members. Full stop. Since that is not considered by the respondent number 1, the petitioner is before this court, challenging the list of committee members that was acknowledged by the respondent number 1 for the term 2022-23, which indicated the name of the respondent number 2 as the president of the petitioner, and also for a direction to the respondent number 1 to consider his representation to register the list of committee members for the year 2023-26 for the term 2023-26. Full stop. Next para. When this petition was listed for orders, the petitioner represented by the president who appeared in person submitted that the respondent number 2 is no longer the president of the petitioner, and therefore the respondent number 1 could not have entertained any representation filed by the respondent number 2 or any list of committee members submitted by the respondent number 2. He submits that the respondent number 2 has not taken any action to restore his position as the president of the petitioner and as directed by this court in WP number 40558 of 2008. He therefore submits that the respondent number 1 could not have entertained the list of committee members submitted by the respondent number 2. Full stop. He also submits that the respondent number 1 was bound to consider the list of committee members submitted by the petitioner as per on 3/6/2024, and since the same is not done, the respondent number 1 is liable to be directed to take appropriate action on the representation filed by the respondent by the petitioner. Stop. Next para. The respondent number 2 has expired. And therefore, expired and there is expired. Full stop. Thus, the respondent number 2 is expired and respondent number 2 has expired. Full stop. Next para. After perusal of the documents furnished by the petitioner along with the writ petition, one fact is evident, namely that the petitioner, that the respondent number 2 was contesting the case of the petitioner that he had resigned from the post of president. He had also contested the claim of Mr. Shivlinga Swami, who claimed to be the president of the petitioner. Full stop. Therefore, the respondent number 2 must have taken steps to restore his position as the president of the petitioner. Full stop. Once the civil court had already declared that Sri Shantavira Swami was the president and Sri Shivlinga Swami was the general secretary of the petitioner, the respondent number 2, having challenged it unsuccessfully in regular appeal and a regular second appeal before this court, could not have indulged in mischief by filing a list of committee members before the respondent number 1. Full stop. The respondent number 1 therefore could not have entertained the request of the respondent number 2, could not have acknowledged the list of committee members submitted by the respondent number 2. To that extent, the case of the petitioner merits consideration. Full stop. Similarly, since the status of Sri Shivlinga Swami as the president is recognized, since the status of Sri Shantavira Swami as the president and Sri Shivlinga Swami as the general secretary of the petitioner was recognized by the civil court and upheld by this court, and in view of the fact that Sri Shantavira Swami has died, and in his place, Sri Shivlinga Swami is elected as the president of the committee of management of the petitioner, the petitioner's list of committee members ought to have been entertained by the respondent number 1. Full stop. Thus, in order to put a quietus to a long-drawn litigation, it is appropriate to dispose of this writ petition on the following terms. Number 1, the writ petition is allowed. The list of committee members submitted by the respondent number 2 before the respondent number 1 for the term
2023 to 26.
For the term
23 to 26.
Next P1, P2, P3 and
P2, P3.
for the term 2022-23. Namely, bracket annexure P1, P2 and P3 are hereby quashed. Consequently, the respondent number 1 is directed to consider the list of committee members submitted by the petitioner on 3/6/2024 and pass appropriate orders regarding registration and approval of the list of committee members. Full stop. This shall be done by the respondent number 1 within a period of 3 months from the date of receipt of a copy of this order. ಇನ್ನೊಂದೇನಿದು?
ಇನ್ನೊಂದಿದೆ ಮೇಡಮ್. Please.
Petition is.
This is a religious institution. One Sri Urling Peddi Samsthana Mata situated in Kodla village. So for them, the previous Mahant, Sri Mahadev Swami has been appointed the petitioner as a successor of the Mutt on 16/2/72. On the basis of that, we have made trust deed also, which is also registered, annexure A. And during the period on 1985, our previous Mahant was expired. Immediately, the respondent number 6, Nanjunda Swami, who has without succession certificate, he has transferred the property of the Mutt. Annexure C, my lord. Transfer without producing the succession certificate has been transferred and sold nearly about 12 acres of land.
ಯಾರಿಗೆ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ?
One San Sabana and another one Karanappa.
ಯಾರಿಗೆ ಸೇಲ್ ಮಾಡಿದ್ದಾರೆ?
San Sabana ಅಂತೇಳಿ ಒಬ್ಬರಿಗೆ.
ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಲ್ಲ ನೀವು? ಅವ್ರನ್ನ ಈ ಕೇಸಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಲ್ಲ? ಅವರಿಗೆ ನಾನು OS ನಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿ ಅಂತ ಹೈಕೋರ್ಟ್ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿತ್ತು. ಅದಕ್ಕೆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ ಚಾಲೆಂಜ್ ಮಾಡಿ TI ತಗೊಂಡಿದ್ದೀನಿ. ಕರೆಕ್ಟ್. ಇಲ್ಲಿ ಪಾರ್ಟಿ ಮಾಡಿಲ್ವಲ್ಲ ನೀವು ಅವ್ರನ್ನ? ಅಲ್ಲ, TI ಕಾಪಿ ಹಚ್ಚಿ ನಾನು. ಈ ಕೇಸಲ್ಲಿ ಏನಾದ್ರೂ ಆರ್ಡರ್ ಆಗ್ಬೇಕು ಅಂದ್ರೆ ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕೋ ಬೇಡವೋ? ಅಲ್ಲ, ಅವ್ರು ಮಾಡ್ಬೇಕು. ಮಾಡಿ. ಆದ್ರೆ ನಾವು ಇಲ್ಲೇನ್ ಮಾಡಿವಿ, ಒನ್ಲಿ ಕ್ವಾಶಿಂಗ್ ದ ಮ್ಯೂಟೇಶನ್ ಅವ್ರು ಕ್ವಾಶ್ ಮಾಡಿದ ಅವ್ರದ್ದು ಟೈಟಲ್ ಡೀಡ್ ಹೋಗುತ್ತಲ್ಲ ಸಣ್ಣ ಸಾಬಣ್ಣಂದು, ಅವ್ರನ್ನ ಪಾರ್ಟಿ ಮಾಡ್ಬೇಕಲ್ಲ ನೀವು. The petitioner who appeared in person seeks time to take steps to implead the purchasers from the respondent number number 6. Full stop. List after the same is done. Another one request is there, my lord. So another person, respondent number 7, without rights, is occupying the property of the Mutt from last 30 years. Yes. He is not paying any rent, any possession. He is not ready to vacate the building. It is the property of the Mutt. So therefore, I am requesting, I made a complaint before the police commissioner, but they have given direction. It is a civil in nature. So if honorable court is given direction, we will ready to give protection. Correct, but if somebody is in possession of some property, you can't throw him out. ನಮ್ಮ ದೇಶದಲ್ಲಿ ಕಾನೂನು ಹೆಂಗಿದೆ ಅಂದ್ರೆ, ಒಬ್ಬ ಮನುಷ್ಯ ಒಂದು ಸ್ವತ್ತಲ್ಲಿ ಸ್ವಾಧೀನ ಇದ್ರೆ ಅವನನ್ನ ನೀವು ಹೋಗಿ ಏಕಾಏಕಿ ಎತ್ತು ಬಿಸಾಕಕ್ ಆಗಲ್ಲ. ಕೋರ್ಟ್ ಮುಖಾಂತರ ಹೋಗ್ಬೇಕು. ಸೊ ನೀವು ಕೋರ್ಟ್ ಮುಖಾಂತರ ಹೋಗ್ಬೇಕು. ಆದ್ರಿಂದ ಹೈಕೋರ್ಟ್ ಬಂದು ನೀವು ಡೈರೆಕ್ಷನ್ ತಗೊಂಡು ಅವನಿಂದ ಎತ್ತಂಗಡಿ ಮಾಡಕ್ ಆಗಲ್ಲ. ನೀವು ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಹೆಂಗೋ ಒಂದು ಕೇಸ್ ಹಾಕಿದಿರಿ. ಆ ಸಿವಿಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಶಂಕರ್ ವಿರುದ್ಧನು ಕೇಸ್ ಹಾಕಿ ಅವನ್ನ ಅಲ್ಲಿಂದ ಖಾಲಿ ಮಾಡಿಸೋದಕ್ಕೆ ನೀವೇನ್ ಬೇಕೋ ಕ್ರಮ ತಗೊಳ್ಳಿ. ಈ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ನೀವು ಎಲ್ಲದಕ್ಕೂ ಹೈಕೋರ್ಟ್ ಅಲ್ಲಿ ನಿಮ್ಗೆ ಪರಿಹಾರ ಕಂಡುಕೊಳ್ಳಕ್ ಆಗಲ್ಲ. ಇದನ್ನ ಇಂಪ್ಲೀಡ್ ಮಾಡಿ ಅವ್ರನ್ನ ಮುಂದೆ ನೋಡೋಣ.
Hearing for the petitioner. Lordship, the present petition is filed because the Annexure D is a representation given by the petitioner who happens to be the member of the Gram Panchayat survey and which has not been considered by respondent number 1. What has happened, your lordship?
Annexure D now.
Yes, lord. Page number 26 to 27. What has happened, your lordship, is that out of 16 members of the Gram Panchayat, 12 members, including the ex-president, are facing disqualification charges because there is a finding by the RC that they have been indulging into financial misappropriation, and to that effect, there is a finding at page number 15, your lordship.
What is your representation? Please read Annexure D.
Your lordship, we have requested the respondent number 1 to not to hold elections for the post of Adhyaksha until an order is passed by respondent number 1 with respect to disqualification.
Please read.
ಈ ಮೂಲಕ ನಾನು ಶ್ರೀಮತಿ ಉಷಾ ಗಂಡ ಕೆ ಬಸಪ್ಪ ಸಾಕಿನ್ ಹರವಿ ಸೊ ಅಂಡ್ ಸೊ ಗ್ರಾಮ ಪಂಚಾಯತಿ ಸದಸ್ಯರು ಹರವಿ ಈ ಪತ್ರದ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ಮನವಿ ಮಾಡಿಕೊಳ್ಳುವುದೇನೆಂದರೆ ರಾಯಚೂರು ಜಿಲ್ಲಾ ಸಿರ್ವಾರ್ ತಾಲೂಕು ಹರವಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ 12 ಜನ ಸದಸ್ಯರ ವಿರುದ್ಧ ಮಾಸ್ಯ ಸರ್ಕಾರದ ಪ್ರಧಾನ ಕಾರ್ಯದರ್ಶಿ ಗ್ರಾಮೀಣಾಭಿವೃದ್ಧಿ ಮತ್ತು ಪಂಚಾಯತ್ ರಾಜ್ ಇಲಾಖೆಯ ತಮ್ಮ ಕಚೇರಿಯಲ್ಲಿ ಸದಸ್ಯತ್ವ ರದ್ದು ಮಾಡುವ ಆದೇಶ ಮಾತ್ರ ಬಾಕಿ ಇದ್ದು ಪಂಚಾಯತ್ ರಾಜ್ ಅಧಿನಿಯಮ 1993 43A 48(4) ರನ್ವಯ ಯಾವುದೇ ಸದಸ್ಯರ ವಿರುದ್ಧ ಆರೋಪ ಸಾಬೀತು ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಅಂತವರ ವಿರುದ್ಧ ಸದಸ್ಯತ್ವ ರದ್ದು ಮಾಡಬೇಕೆಂದು ಕಾಯ್ದೆ ಇದ್ದು ಸದರಿಯವರು ವಿರುದ್ಧ ಸದಸ್ಯತ್ವ ರದ್ದತಿ ಆದೇಶ ಬರುವವರೆಗೂ ಹರವಿ ಗ್ರಾಮ ಪಂಚಾಯತ್ ಅಧ್ಯಕ್ಷರ ಚುನಾವಣೆ ದಿನಾಂಕವನ್ನು ಘೋಷಣೆ ಮಾಡಬಾರದು. Sir, your lordship, this has been submitted on 7/12/2024 before Annexure E was issued. Annexure E is the notice for election at page number 28. Your lordship, what has happened is that the whole transaction is of the year 2020, 2021, your lordship. And at Annexure B1, respondent number 1 has issued show cause notice to 12 members with respect to the findings given by the regional commissioner, which is at page number.
Organization be headless, Mr.
Your lordship,
How can an organization?
your lordship, section 43 and 44 of the Karnataka Gram Panchayat Act says that in absent, because the last president was removed on 7/12/2024, your lordship, there is an upadhyaksha, and in case if there is an upadhyaksha or if there is no upadhyaksha, the deputy commissioner can appoint a person to act as an adhyaksha, lordship. Upadhyaksha is already there. I mean, it is a respectful submission, your lordship, that there is no hurry to appoint an adhyaksha because only 10 months are remaining in this whole term, your lordship. And if they take another 4 months to decide the validity of membership, the petitioners who have been.
Did you move this matter at 2:30?
Your lordship, tomorrow the Annexure E has been challenged, your lordship, where I have challenged the notice issued for election of Adhyaksha. It is to be held tomorrow, your lordship. So I'm seeking stay of that election. Because, your lordship, what will happen, if I may submit with your lordship's permission, is that if tomorrow an Adhyaksha is, because there is no SC candidate, out of 16 people, 12 are one side and 4 are other side, your lordship. Out of these 4 people who are not having any allegations, there is no SC candidate. And 12 of them are having a majority, your lordship. If tomorrow, if one of them is elected, and if, let us say, out of 12, there are 8 people who are disqualified because there is a categorical finding against all 12 of them that they have misappropriated funds with respect to Gram Panchayat. If everybody is disqualified, your lordship, it is, in my humble submission, it is waste of time and valuable resources of the State Election Commission. What happens, your lordship, in case they are disqualified, the State Election Commission and the DC have to call for fresh election, members have to be elected, and then another Adhyaksha has to be appointed. Meanwhile, there is Upadhyaksha, your lordship, who can dispense the function of Adhyaksha. That is my only prayer.
Who is the Upadhyaksha?
Your lordship, there is Upadhyaksha.
Upadhyaksha belongs to the 4.
Yes.
ನಿಮ್ 4 ಜನದಲ್ಲಿ ಒಬ್ಬ ಉಪಾಧ್ಯಕ್ಷ.
Yes, your lord.
So
Upadhyaksha has not been removed. He is still there.
So Upadhyaksha has not filed this petition. Somebody else has filed to.
It is a member out of 4 people who have no allegations against them have filed this petition.
Let the elections go on for full.
Your lordship, if I may submit, your lordship, if
The shadow boxing, will not.
I understand, that is the reason I have submitted.
No, any shadow boxing.
I understand, your lordship. That is the reason I have given your lordship the complete picture of what has happened. And I'll be more than courteous to the court that your lordship has heard me. But if your lordship in the next 10 months, which is remaining, I'll be unable to do anything, your lordship. At least my representation at D may be considered, and the inquiry and because in B and B1, your lordship, show cause notice is issued and they have not appeared at all. The 12 of them have not appeared, your lordship. If the investigation is completed within 2 months, it will be more than what I would
You will not
ask for.
press the other reliefs.
Yes, your lordship. If the inquiry is completed and an order is passed by a respondent number within 2 months, that I'll not press the other prayer of quashing, your lordship.
Could AG is directed to accept notice for response 1, 2, 3, 4. Chief Taluk Panchayat yaru Raichur.
Your lordship,
Advocate for that.
Amargundappa,
Arun Kumar.
Amargundappa, your lordship.
Arun Kumar Amaragundappa is directed to accept notice for respondents 5, 6, and 7.
Yes, sir.
ಇದು order sheet ಅಲ್ಲಿ ಮಾಡಿ. The petitioner claims to be a member of a Gram Panchayat at Harvi. Full stop. Harvi, which comprises of 16 members.
Yes, your lordship, 16 members.
Full stop. He contends that on a complaint lodged by one Bhimanna Naik against the erstwhile president of the Panchayat and 11 members, an inquiry is initiated by the respondent number 2. The respondent number 2 has submitted a report dated 19/7/2024, holding that the 12 members of the Panchayat were guilty of misappropriation of funds in the name of their relatives, and recommended suitable action against the 12 members under section 43A and 48(4) of the Karnataka Gram Swaraj and Panchayat Raj Act 1993. Full stop. The respondent number 1 issued a show cause notice dated 26/8/2024 and 2/12/2024 to the 12 members of the Panchayat based on the report submitted by the respondent number 2. It is alleged that the said 12 members had not submitted any reply to the notice issued by the respondent number 1. When things stood thus, a no confidence motion was, things stood thus, a representation was submitted by 2/3 members of the Gram Panchayat on 7/12/2023, expressing no confidence against the president of the Panchayat. They said no confidence motion was passed at the meeting.
My lord, 7/12/24.
24.
On the meeting, resulting in the post of the president of the Panchayat falling vacant. Full stop. The petitioner, being a member of the Panchayat, submitted a representation dated 7/12/2024 to the respondent number 1, requesting it not to conduct fresh election to the post of Adhyaksha/President of the Panchayat. Full stop. The petitioner contends that the respondent number 3 has now appointed the respondent number 6 as the returning officer for conducting election to the post of Adhyaksha, which is scheduled to be held on 8/1/2025. Full stop. Being agreed by the non-consideration of the representation of the petitioner dated 7/12/2024 and the notice dated 24/12/2024, proposing to hold elections to the post of Adhyaksha on 8/1/2025. The petitioner is before this court. Next para. The learned counsel for the petitioner contends that 12 members out of 16 are already facing disqualification, and therefore, no proceedings can be taken out for electing a president of the panchayat. Full stop. He submits that the respondent number 1 was bound to consider the representation of the petitioner dated 7/12/2024. 7/12/2024. And must have 7/12/2024. So full stop. He submitted that the vice president is already officiating as the president of the panchayat, and therefore, and that the term of the panchayat is only 10 months from now, and hence no useful purpose would be served in conducting elections to the post of Adhyaksha. Full stop. Per contra, the learned AGA submitted that as on date, there is no disqualification of the members of the panchayat, though proceedings are initiated against 12 members of the panchayat. He submits that in view of the no confidence motion, against the president, in view of the passage of the no confidence motion against the president, the post of president has fallen vacant, and therefore it is necessary for conducting proceedings to elect a president of the panchayat. He therefore further contends that any election that may be held shall be subject to the proceedings before the respondent number 1. Full stop. He, however, submitted that the representation of the petitioner shall be considered in accordance with law. Full stop. Next, I have considered submissions of the learned counsel for the petitioner and the learned AGA for the respondents 1 to 4. Next para. It is not much in dispute that proceedings are initiated against 12 members of the panchayat under section 43A and 48(4) of the Karnataka Panchayat Raj Act 1993. Full stop. However, full stop. It is also not in dispute that the erstwhile president of the panchayat, it is not in dispute that a no confidence motion was moved successfully against the erstwhile president of the panchayat, resulting in his seat falling vacant. Full stop. The official respondents were therefore justified in taking steps to elect a president, as the panchayat cannot function headless. Full stop. The claim of the petitioner that many members are facing disqualification, and therefore no purpose would be served in electing the president of the panchayat, cannot be accepted, as the members are deemed to be in office until they are disqualified in accordance with law. Therefore, the elections to the post of president scheduled on 8/1/2025 cannot be interfered with. However, it deserves to be made clear that the election of the president to the election of a member to the post of president shall always be subject to the result of the proceedings before the respondent number 1 under section 43A and 48(4) of the Karnataka Panchayat Raj Act 1993. Full stop. Insofar as the representation submitted by the petitioner to the respondent number 1, it is no doubt true that the respondent number 1 owed a duty to the petitioner to consider the representation submitted, more particularly in view of the proceedings pending before it. Full stop. Consequently, a direction deserves to be issued to the respondent number 1 to consider the representation of the petitioner in accordance with law. Hence the following order. The writ petition is allowed in part. The The representation of the petitioner dated 7/12/2024 shall be considered by the respondent number one in accordance with law. After, for accordance with law, it is needless to mention that before such consideration, the respondent number one shall hear all the concern and pass appropriate orders. Full stop. The consideration of the representation shall be within a period of 2 months.
Yes, already notice issue. Notice issue ಮಾಡಿ 27 date as given.
Your Lordship, 27, there was no meeting held because there was a holiday, general holiday.
Madam, I think within a period of 2 months from the date of receipt of a
Yes,
certified copy of this order.
Much obliged.
Aruna P. Chavan.
My lord, petitioner is the president of Morambi Gram Panchayat.
Madam, use the mic.
My lord, petitioner is the president of Morambi Gram Panchayat, against whom the out of 16 members, 14 members moved annexure C, page number 17, without any allegation, my lord.
Allegation act ಬಂತಿಲ್ಲಿ.
Allegation ಇಲ್ಲ ಸ್ವಾಮಿ, but one document I need to take from the client is unable to provide.
Allegation ಮಾಡಿದ್ರೆ ಮಾತ್ರ ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಮೂವ್ ಮಾಡ್ಬೇಕು ಅಂತ
ಇಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ PDO ಅವರು ಒಂದು ಲೆಟರ್ ಕೊಟ್ಟಿದ್ದಾರೆ 12th, ಅದಕ್ಕೆ ನಾನು ಇವತ್ತು ಮೆನ್ಷನ್ ಮಾಡಿಲ್ಲ ಅದರಲ್ಲಿ. ಬರೀ ಅದರಲ್ಲಿ ಅವರು ಟ್ರಾನ್ಸ್ಫರ್ ಕೇಳಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಯಾರು PDO ಅವರು ಟ್ರಾನ್ಸ್ಫರ್ ಇವ್ರು ಮಾಡ್ಲಿಲ್ಲ ಅಂತ ತಿಳ್ಕೊಂಡು ಅದು ಕಾನ್ಸ್ಪಿರಸಿ ಮಾಡ್ಕೊಂಡು ಇದೆಲ್ಲ ಇದು ಮಾಡಿದ್ದಾರೆ.
ಅದಕ್ಕೂ ಇದಕ್ಕೆ ಸಂಬಂಧ ಇಲ್ಲ.
ಆಮೇಲೆ ಇದು annexure C ಮೇಲೆ the members has given that representation to the Tahsildar, not to the commissioner, but addressing to the commissioner.
Annexure C is addressed to the Sahayaka Ayukta.
Addressed to the commissioner,
Assistant Commissioner.
but given to the Tahsildar.
Sahayaka Ayukta.
ಆಯುಕ್ತರು ಬಸವ ಕಲ್ಯಾಣ ಜಿಲ್ಲಾ ಬೀದರ್.
ಸಹಾಯಕ ಆಯುಕ್ತರಿಗೆ ಕೊಟ್ಟಿರೋದು ಇದು.
Addressing to the proper office.
ಎಲ್ಲಿದೆ? Annexure C ಓದಿ.
Annexure C ದಲ್ಲಿ ಸ್ವಾಮಿ ಮೇಲೆ ಇದೆ, ಸಹಾಯಕ ಆಯುಕ್ತರು ಬಸವ ಕಲ್ಯಾಣ ಜಿಲ್ಲಾ ಬೀದರ್. ಕೆಳಗಡೆ ಸಿಗ್ನೇಚರ್ ಎಲ್ಲ ನೋಡಿದ್ರೆ ತಹಸೀಲ್ದಾರ್ ಅವ್ರದ್ದಿದೆ, ಕಮಿಷನರ್ ಅವ್ರದ್ದಿಲ್ಲ. Annexure ಇದರಲ್ಲಿ D ದಲ್ಲಿ ಕಮಿಷನರ್ ಅವ್ರ ಸಿಗ್ನೇಚರ್ ಇದೆ ಸ್ವಾಮಿ.
ನಿಮ್ಗೆ ಇದು ಹೆಂಗ್ ಸಿಕ್ತು?
ಯಾವ್ದು ಸ್ವಾಮಿ?
How did you get annexure
ಅದು
C?
ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡಿದೆ.
ಅಲ್ಲಮ್ಮ, ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ಸೀಲ್ ಹೆಂಗ್ ಒರಿಜಿನಲ್ ಇದೆ ಇದು?
ಅದೇ ಸೀಲ್ ಇದೆ ಸ್ವಾಮಿ ಇದರಲ್ಲಿ, ತಹಸೀಲ್ದಾರ್ ಅವ್ರದ್ದು ಸೀಲ್ ಇದೆ ಇದರಲ್ಲಿ.
ತಹಸೀಲ್ದಾರ್
ತಗೊಂಡಿದ್ದಾರೆ.
ಸಹಾಯಕ ಆಯುಕ್ತರ ಕಚೇರಿ.
ಹೌದು ಸ್ವಾಮಿ.
ನೀವು ಸರ್ಟಿಫೈಡ್ ಕಾಪಿ ತಗೊಂಡಿದ್ದೀರಾ ಅಷ್ಟೇ.
ಹೌದು ಸ್ವಾಮಿ.
ಅಲ್ಲಿ ತಹಸೀಲ್ದಾರ್ ಸೀಲ್ ಹಾಕಿ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಮತ್ತೆ ಅದ್ರ ಮೇಲೆ ಅವ್ರಿಗೆ ಕಾಪಿ ಕೊಟ್ಟಿದ್ದು ಅವ್ರ ಸಿಗ್ನೇಚರ್ ರಿಸೀವ್ಡ್ ಅಂತ ಎಲ್ಲೂ ಇಲ್ಲ ಸ್ವಾಮಿ.
ಎಸ್, ಬಟ್ ನಿಮ್ಗೆ ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ರು 3/2 ನಲ್ಲಿ ಇಶ್ಯೂ ಮಾಡಿದಾರಲ್ಲ.
ನೋಟಿಸ್ ಇಶ್ಯೂ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ, ಅದ್ರ ಮೇಲೆ ಅವ್ರದ್ದು ಸಿಗ್ನೇಚರ್ ಇದೆ.
So therefore, how do you say that they are not received?
Because he has not taken care of that procedure. That's the sheer violation of the established procedure.
ಏನಂತ ಯಾವುದು? What is violated? Please point.
Rule 3 provides that at least 2 members should be present and give their letter of no confidence to the assistant commissioners.
How do you say that 2 members were not present?
ಅಂದ್ರೆ ಅವ್ರದ್ದು ಸಿಗ್ನೇಚರ್ ಇಲ್ಲ ಸ್ವಾಮಿ ಅದಕ್ಕೆ.
ಅದು ಹೆಂಗಾಗುತ್ತೆ?
Endorsement is not there.
ಹೆಂಗಾಗುತ್ತೆ ಅದು?
Because the document we have obtained through proper channel, certified copy is there. So election is scheduled tomorrow, my lord. At least one big stay may kindly be granted.
ನಿಮ್ ಕೇಸ್ ಗೆದ್ದಂಗೆ ನೀವು.
ಇಲ್ಲ ಸ್ವಾಮಿ, ಯಾಕಂದ್ರೆ ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಕೊಟ್ರೆ at least I'll furnish all those documents. They are unable to get those documents.
ಮೇಡಮ್, 8/1/2025 ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಆಗದಿದ್ರೆ ನೀವು ರಿಟ್ ಪಿಟಿಷನ್ ವಿಡ್ರಾ ಮಾಡ್ಬೋದು. ಕೇಸ್ ಗೆದ್ದಂಗೆ ತಾನೆ. Is it your case that annexure C was not submitted by the members?
Yes.
ಮಾಡಿಲ್ವಾ? Is it your case that annexure C is not submitted by the members of the panchayat? ಎಲ್ಲಿ ಹೇಳಿದಿರಾ ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ?
ರಿಟ್ ಪಿಟಿಷನ್ ಅಲ್ಲಿ ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ.
ಎಲ್ಲಿ ಹೇಳಿದಿರಾ? ಓದಿ.
On which date the 14th members out of 16 have submitted their written requisition to the
ಎಲ್ಲೋ ಓದ್ತಿದ್ದೀರಾ?
synopsis ಅಲ್ಲೇ ಹೇಳಿದ್ದೀನಿ ಸ್ವಾಮಿ. 4th ಇದರಲ್ಲಿ synopsis ಅಲ್ಲಿ.
ಪಿಟಿಷನ್ ಎಲ್ಲಮ್ಮ ಹೇಳಿದಿರಾ? ಈ ಅರ್ಜಿ ಕೊಟ್ಟೇ ಇಲ್ಲ ಅವರು ಅಂತ ಎಲ್ಲಿ ಹೇಳಿದಿರಾ?
ಅರ್ಜಿ ಕೊಟ್ಟೇ ಇಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಿಲ್ಲ, ಬಟ್ ಇದರಲ್ಲಿ ಹೇಳಿದೀನಿ ಸ್ವಾಮಿ, ದೇ ಹ್ಯಾವ್ ವೈಲೇಟೆಡ್ ದಿ ಎಸ್ಟಾಬ್ಲಿಷ್ಡ್ ಪ್ರೊಸೀಜರ್ ಅಂತ ಹೇಳಿದ್ರಿ. ನಾಟ್ ಫಾಲೋಡ್ ದ ಡ್ಯೂ ಪ್ರೊಸೀಜರ್ ಆಫ್ ಲಾ.
Page 6 of your writ petition, Bunny.
ಹಾ ಸರ್.
However, 14 members who are not interested to continue the petitioner as a president due to politically motivated and personal interest, which is clear from the letter of PDO dated 12/12/2024, as he wants to take transfer to the place of his choice. And very next date, that is on 13/12/2024, 14 members are not interested to continue the petitioner, submitted an application to the Assistant Commissioner on 13/12/24, expressing no confidence motion against the petitioner, though there was no provision to express no confidence in the absence of any lapses. So ನೀವು ಅರ್ಜಿ ಕೊಟ್ಟರೋದು ನೀವು ಒಪ್ಕೊಂಡಿದ್ದೀರಿ.
ಅಡ್ರೆಸಿಂಗ್ ಟು ಹಿಮ್ ಸ್ವಾಮಿ.
ಯಾರಿಗೆ?
ಅಸಿಸ್ಟೆಂಟ್ ಕಮಿಷನರ್ಗೆ ಅಡ್ರೆಸ್ ಮಾಡಿದ್ದಾರೆ ಅವರು.
ಹೌದು.
So annexure Cs I have produced. So which clearly shows that there is no endorsement of the assistant commissioner. So kindly at least 1 week stay may kindly be granted. I'll produce the letter of the PDO.
Sorry.
The conspiracy is there, my lord.
Issue emergent notice. Sorry, the AG is directed to accept notice for response 1, 2, and 3. Issue emergent notice to respondent number 4. The no confidence motion scheduled to be held on 8/1/2025 shall be subject to the result of this petition.
And I may be permitted to make a necessary correction in the petition, my lord. There are some
Are you
corrections
what?
are there.
Mad.
Your lordship, permission 5, 6, 7, your lordship, for Gram Panchayat Raichur. It is Gaurish Kashampur and not Amargunda.
Huh?
It is Gaurish Kashampur, your lordship. 5, 6, and 7.
Huh.
Lordship has asked.
Arun Kumar alva?
He is not.
Gaurish Kashampur anta.
Much obliged.
Yeah, ಅಷ್ಟೇನಾ?
Lordship, one request. Serial number 1, I want to withdraw
Withdraw.
because notice is,
Learned counsel for the petitioner has filed a memo to withdraw the petition.
and serial number 2 that, sorry for 2 minutes. That is not a prohibition, that is a certiorari and
ಸರ್ಶ್ಯೂರರಿನೂ ಅಲ್ಲ.
ಇಲ್ಲ higher court has a power to direct the lower courts ಅಂತ ಇದೆ certiorari.
ಮೇಡಮ್ ಸರ್ಶ್ಯೂರರಿನೂ ಬರೋಲ್ಲ. ನೀವು ದಯವಿಟ್ಟು ಓದಿ.
Bashing along with certiorari.
ಅದು ಬರೋದಿಲ್ಲ.
ಹೌದು, please.
ಅದು ನೋಡಿ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ.
Please. ಇಲ್ಲ ಅದು.
ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಜ್ಮೆಂಟ್ ಇದೆ ನೋಡಿ.
ಸರಿ.
ಮೇಲಿನ ಕೋರ್ಟ್ಗೆ ರಿಟ್ ಇಶ್ಯೂ ಮಾಡಕ್ ಬರಲ್ಲ.
Please. ನಾನು ನೋಡ್ತೀನಿ.
There is a full bench judgment of the Supreme Court. Please look into that.
Please.
Dismiss
Afterwards,
as-
I will make a correction that liberty will be
ಸುಮ್ನೆ ಡೈರೆಕ್ಷನ್ ಅಂತ ಹೇಳ್ಬೇಕು ಅಷ್ಟೇ.
ಅಷ್ಟೇ ರೀ.
ಈಗ ಅವರಿಗೆ
ಹಾ ರೀ.
ಸರ್ ಒಂದ್ ಸ್ವಲ್ಪ ಎಂಡ್ ಆಫ್ ಲಿಸ್ಟ್ ಸರ್. ಒಂದ್ ನಿಮಿಷ ತಾರಿ ಅದ್ ನಂಬರ್ ಬರ್ತಾವ.
Only direction of it.
ಅದ ಎಂಡ್ ಆಫ್ ಲಿಸ್ಟ್ ತಾರಿ ಅವ್ ನಂಬರ್ ಬರ್ಕಳ. ಇಲ್ಲ ಇದು ನಂಬರ್ ಬರ್ಕಂತೀನಿ ಅದನ್ನು ನಮಗ ನಂಬರ್ ಇಲ್ಲ ಮಾತ್ರ. ಒಂದ್ ನಿಮಿಷ. ನಮಗ ನಮ್ಮದ್ರಿ ಏನು ಇರೋದು ಅದು ಅದ್ರ ಮರ್ಮೇಲೆ ಅವೇ ಕೇಳ್ಬೇಕಂತ ಶ್ರೀನಾಥ್ ಹೇಳಿ.
Serial number ಆಗಿಲ್ಲ sir, notice. ಎರಡರಲ್ಲಿ ಅದು ಡೈರೆಕ್ಷನ್ ಯಾಕೆ ನೋಟಿಸ್ ಬೇಕು?
ನಮಸ್ಕಾರ. ಏನಾದ್ರು ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಏನಾದ್ರು
ಒಂದು ಮ್ಯಾನಮಸ್ ಇತ್ತು, ನೋ ಕಾನ್ಫಿಡೆನ್ಸ್ ಹೋಯ್ತು.
ಹಾ ಹಲೋ
ಸಹೋದರ ನಾ ಅಲ್ಲೇ ಅದೇ ಇಲ್ಲ ಮನೆ ಫೋನ್ ಮಾಡಿದ್ರು ನಾನು ಫೋಟೋ ಕೇಸ್ ಅದಕ್ಕೆ ಮಾಡ್ತೀವಿ ಎಲ್ಲ ಹ್ಮ್ 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 ಆಯ್ತು ಕೊಡ್ತಾವ ಎರಡು ಅದಿ ಭಾಳ ಅಲ್ಲ ಸೂಪರ್ ಇಲ್ಲ ನಾವು ಹೋಗಿ ನಾವಾಗ ಸೀದಾ ಯಾಕಂದ್ರ ನಾವು ಕೋಶಿಶ್ ಮಾಡೋರಲ್ಲ ಈಗ ಮುಗ್ದೈತ ಹನ್ನೊಂದು ಇಲ್ಲ ನಿನ್ ಕೆಲಸ ಮುಗ್ದೈತ ಆಯ್ತು ಒಂದು ಅರ್ಧ ಗಂಟೆದಾಗೆ ಬರ್ತೀನಿ ಒಂದು ಸ್ವಲ್ಪ ನಾನು ಕೊಟ್ಟಾಗ ಅದೀನಿ ಸೂಪರ್ ಅನ್ನ ಯಾರ ಕೊಡ್ಬೇಕಾತ ಅವ್ರೇ ಅನ್ನ ನಮ್ಮನ್ಯಾಗ ಇದು ಮಾಡ್ತಾರ ಅದಕ್ಕೆ ನಾವು ಅಲ್ಲೇ ಆಫೀಸಿಗೆ ಬರ್ ಅಲ್ಲೇ ಇರ್ತೀನಿ ಹೇಳ್ರಿ ಸರ್ ಬಸವರಾಜ್ ಬಸವರಾಜ್ ಚಿಂಚೋಳಿ ವಕಾಲತ್ನಲ್ಲಿ ಇಲ್ಲ ಹಂಗೆ ಅವ್ರ ಕಲಿ ಒನ್ ಆಫ್ ದಿ ಮೆಂಬರ್ ಕಮಿಟಿ ಡಿಸ್ಮಿಸ್ ಆಯ್ತು ಕಮಿಟಿ ಮೆಂಬರ್ ಇದು ಡೇಟ್ ಕೊಟ್ರ ಕೊಡ್ಲಿ ಇವು ಎಲ್ಲ 9 ಇಟ್ರಲ್ಲ ಟೆಂಡರ್ ಮ್ಯಾಟ್ 51 52 ಡೇ ಆಫ್ಟರ್ ಟುಮಾರೋ 50 ಅದೇ 9/1 52 53 ಎಲ್ಲ 9/1 ಅದಿನ್ನ ಕಿರಿಕಿರಿ ಬಗೆಹರಲ್ಲ ಅದು ಇವೆಲ್ಲ ಈಗ ಲೆಟರ್ ಮಾಡಿಸ್ಬೇಕು ಇದೊಂದು ಕೆಲಸ ಈಗ ಚಾಲು ನಮ್ ಜಾಗಕ್ಕೆ ನಮ್ಗೆ ಇಟ್ರ ಫೈಲ್ ನಮ್ಮ ಹತ್ರ ಬರ್ತಾವ ಈಗ ಎಲ್ಲ ಫೈಲ್ ಇಟ್ರ ನಮ್ಮ ಹತ್ರ ಫೈಲ್ ಮಿಕ್ಸ್ ಮಾಡಿ ಬಿಡ್ತಾರ ನಾವು ನಮ್ ಜಾಗ ಎಲ್ಲ ಒಂದು ಫಿಕ್ಸ್ ಮಾಡಿ ಅಲ್ಲಿ ಇಟ್ಟು ಅಂದ್ರೆ ಕರೆಕ್ಟ್ ಅಂತ ಅಂದ್ಕೊಡ್ತಾರ ಇಲ್ಲಿ ಕೆಳಗೆ ಇಟ್ಟ ಅಂದ್ರ ನಾನು